forgetting about the water thing. Happened to say to him, would you like some? He said, would be very helpful. So he needs to tell us to see yeah. They're still chatting. But won't they might just talk. Sorry? Yeah. Do you want to tell her it's ready or not interrupt? Yeah, it's ready. Who's different to you? Apart from you. They're open. I asked them to do this. The JAs are not included. 7 people. Well, that's the JAs. Oh, who's the JAs in here? Anyone? Sorry? Oh, the JAs in here then? Yeah. Okay. I'm Jay. Oh, okay. She know they're ready. Ready? Yes. Silence for five. Partner appeal in the matter of BTI 2014 LLC and Pricewaterhousecooper LLP and another.
Thank you. Good morning. Just before you start, Mr. Thompson, since we're starting a little early this morning, perhaps I should signal now. I think we will have a break for the shorthand writer at about 11:30, and please remind me if I look like forgetting that.
My Lord, certainly. Thank you. And thank you very much to your Lordships for sitting early. That's great. My Lords, first, there are a couple of matters outstanding from the closing exchanges yesterday. I hope that my Lords have had via email 2 hand-ups. One is the original particulars of claim, which my Lords requested. I don't propose to say anything about that for the moment, unless my Lords have got any questions about it. The second is the Kennicott case that my Lord Justice Flaux mentioned. I hope my Lords have had that. I mean, that, I don't know whether it's to hand, but it is pertinent indirectly to what we've actually been discussing.
Yeah, I mean, that's what that's why I referred to.
Indeed.
Because, I mean, it doesn't set down any principle, as I said. I reread it last night. It doesn't lay out any principle, but it has a case management spat, if I can put it that way, which in its way is not dissimilar to the one in the present case. And that's, I think, why it seemed to me it might be of some assistance.
My Lord, absolutely, and we're most grateful because, with respect, we agree that's the point one gets out of it, because one sees that there was an issue estoppel point,
Yeah, which obviously isn't
which
here.
isn't here, there was a collateral attack abuse point, which effectively fell away with the issue estoppel point, because in that case, the defendant in the second proceedings was a party to the first proceedings. And the case management point, which my Lord Justice Flaux identifies, of course, arose in relation to what was effectively an alternative abuse point on broadly Henderson and Henderson ground. And there was, we respectfully agree, exactly the sort of case management point that echoes what happened here, because if I could just flag up what we get out of it, and then my Lords will have a chance, obviously, to read it if time permits and see whether my Lords agree with me or not. But the point there is that there was, in the first proceedings, a preliminary issue hearing fixed. As I say, the defendant in the second proceedings was actually a party to the first proceedings. And so in the first proceedings, in the run-up to that preliminary issue hearing, the claimant ventilated the possibility of amending in the first proceedings to add claims against Minette, the relevant defendant, which were the claims that were eventually pursued in the second proceedings. And they exchanged, the two parties exchanged correspondence about it. It was clear that the preliminary issue hearing would be put in jeopardy because that application for amendment would be opposed. And there was what was described as tactical posturing correspondence, and the matter was never ventilated before the court, but the claimant had made it clear that it wanted to bring these claims against Minette, and Minette had simply said it would oppose the application for permission. Now, it's interesting to see how the Court of Appeal dealt with that exchange in the context of the Henderson type abuse. And in particular, I would draw the Court's attention to paragraph 75 of Lord Justice Pill's judgment, where he said that the second action is not an abuse of the process in the circumstances, because Minette did not agree to the holding over of a claim against them, but were party to the course events took with full knowledge of the circumstances. They cannot be heard to say that the claimants are abusing the process of the court by bringing the present action against them, nor is the court affronted. And the case management circumstances there were weaker than one has here because the court wasn't involved at all.
Yes, I mean, this case is a fortiori, you would presumably say, not least because PwC agreed to the consent order.
Precisely. So there was no agreement in that case, there was no involvement on the part of the court, but the parties had ventilated their positions, and so the defendant, Minette, knew exactly what the claimant's position was, and was in that sense party to the course events took, as Lord Justice Pill put it. So that's the point we get out of Hennicock. And the relevant paragraphs generally are, well, the head note, and then Lord Justice Chadwick 43 to 49, Lord Justice Longmore 65, and Lord Justice Pill 74 to 75. Now, my Lords, the one other point just that I mentioned at the end of yesterday, I'll just finish. The question of the strikeout application that PwC wanted to make and did make in 2015. Mr. Lloyd, in his fifth statement at paragraph 294, explains what happened to the various grounds there. Just identify that for my Lords. I said our take on the nature of that application and its effect was rather different to that suggested to the court by my learned friend yesterday.
So where is Mr. Lloyd's?
It's in volume 3, tab 45, and paragraph 294 is at 8.
29.
It's paragraph 294, page 834.
Thank you.
And what he does is really just to explain what happened to the various grounds. Some were dropped by PwC, ground 1, most of ground 2, and ground 7. Some were simply hopeless on the face of the pleading, that's ground 5. Some were addressed by amendments that we made, but those are relatively narrow compass and significance. That's ground 4 and ground 6. And some remained in the 2018 strikeout application that came before Mr. Justice Fancourt. And of course, as regards those, all 4 were rejected, all 4 of those grounds, and 2 have received permission to appeal and are before this court now. 2 died a death at first instance.
Yeah.
So that's basically what happened in the 2015 strikeout application. Now, well, the final case management point that I didn't quite get to yesterday very briefly is a point in relation to the stay order. PwC raised an additional point. They say, they didn't say it in the skeleton below, but they made a point in reply submissions below, that actually the stay of the second proceedings, these proceedings in October 2015, shows, they say, that everyone intended that the claimant would not be allowed to pursue these proceedings if, in fact, it lost in the sequoia. We profoundly disagree with that. There's no evidence for that. That's pure assertion. And actually, when one looks at it, it doesn't stand up to analysis at all. The obvious reason for the stay was, as I indicated yesterday, that if the first proceedings were successful and recovery was made, then to that extent there wouldn't be any loss which could form the subject matter of the second proceedings. It wouldn't be a matter of whether BTI wanted to pursue the claim, it simply wouldn't be able to. And so for that reason, obviously, it could be a complete waste of time and money for everyone for the second proceedings to be pursued separately, as by this stage they were going to have to be, until the question of loss had been resolved in the first proceedings. So you can't draw the inference that PwC invite. In fact, if anything, we'd say if an inference has to be drawn, it's the opposite. Because the stay had an obvious purpose.
Well, the stay effectively put the proceedings on ice until resolution, as it's defined, which is after the determination of the claim against the directors, at which point either party could revive the proceedings, including the applications to strike out.
Yes.
All of which you would say is predicated upon the possibility, at least, that the second set of proceedings are still on foot.
Precisely. So there was nothing agreed at the time, there was nothing in the order, and there's no inference that can be drawn. So really one doesn't get anything out of that at all.
And I think it's right to say there's nothing in the skeleton arguments to suggest anybody directed their minds to the particular problem we're confronted with now.
No, going back to June, no.
Going back to June, yeah.
No,
sorry, yes.
No, I mean,
Yes.
really, one can make very similar points as regards inferences to be drawn in relation to the June consent order and also, sorry, the July consent order.
Yes.
And also the October consent order. But the October consent order was purely that, it was just a consent order. Parties agreed. So, well, there's nothing that one gets out of that. One final loose end, the appeal point. I mean, just in passing, the question was asked, well, why did we not pursue the could not appeal? That's also explained in Mr. Lloyd's statement. In particular, at paragraph 258, we don't need to turn it up perhaps, but it's paragraph 258, excuse me, page 810. And the point was simply, as he explains, that Sequana actually, to everyone's surprise, had gone into a French insolvency process, literally the working day after Mrs. Justice Rose made her order after the consequentials hearing in early 2017. So Sequana was effectively apparently bust. In that context, we clipped our wings in relation to the appeal. We still obviously had the possibility of a claim against the directors, who, as we assume, are insured. So that's the position in relation to the appeal. PwC submit that we should have carried on with the appeal, effectively just to get the findings that were adverse to us that Mrs. Justice Rose had made reversed so that we wouldn't have to pursue inconsistent contentions in these proceedings. But that is frankly a rather useless thing for us to do for that purpose, because if we'd pursued the appeal, that would have been great as regards Sequan and the directors, but nothing that the Court of Appeal might have done would of course have bound PwC at all. So in terms of these proceedings, pursuing the appeal was really of no assistance at all. Now, that's really what I've got to say, my lords, about the case management issue. As my lords know, we say that actually answers the case.
Well, you say that's a complete answer.
Yes.
Even if these proceedings are a collateral attack on Mrs. Justice Rose's judgment, you say it's not possible to say that this is an affront to the administration of justice, given the case management.
Well, my lord, precisely so.
And that you confirmed that, I think, in an answer to a question I asked you yesterday. Can I just ask you one point? Because I had not, until you asked us to look at it overnight, I had not looked at the skeletons. And there's just one point in relation to that. In your skeleton, you said expressly there would be a real risk of inconsistent findings if the dividend claims and PwC claim were not heard together. So that's the inconsistent finding point. I was struck that in the defendant's skeleton, they said, as amongst the many reasons in the balance as to why the joint trial application shouldn't be accepted, they said the balancing exercise lies in favour of dismissing the PwC application as the claimants will suffer no prejudice if the actions are tried separately, and they do not suggest otherwise. Now, reading that, it rather assumed, I'm bound to say that I inferred from that although you were saying there were inconsistent findings, it had not occurred to anybody that there would be inconsistent findings which you wouldn't be able to at least challenge in a second trial. They say there would be no prejudice to you and you're not suggesting otherwise. And that must only be surely because there would be, you would have the opportunity, if that's what happened, to seek inconsistent findings.
My lord, with respect, precisely so, yes. That's a point we rely on, because we say we made the application on the premise that there was a risk of inconsistent findings, which would be most likely in exactly the events that have occurred. Yes.
But as my lord says, beyond that point, the point that we're now wrestling with didn't arise, certainly expressly on the face of the skeletons, as far as, certainly speaking for myself, as far as I could tell.
My lord, I think that's right.
Yeah, okay. Thank you very much.
May I just make clear that the defendants that are being referred to in Justice Coulson is not
the
not
directors.
Yes.
Oh yes, no, it's
Yeah.
the defendants are the defendants in the
Sequana defendants.
the Sequana defendants in the
Yes.
previous proceedings. Your skeleton, which I've also read, this was not a point that arose at all.
Well, I'll
in
come
the
back to that reply if I
PwC
may.
skeleton.
It does, but I'll come back to it.
Okay.
Thank you, Lord. Now, so the case, our primary position on the case management point is exactly as identified. But of course, if my lords are not with me on that, it's still a highly material factor in the mix. So point one is it answers the case completely. But point two, even if it doesn't, that doesn't mean it's irrelevant. On the contrary, it's still highly material. And that one can see from paragraph 100 of the judge's judgment that that's how the learned judge dealt with it. It was one of the 6 factors he identified in summing up as to why it wasn't an abuse. But what I want to deal with now, essentially, my lords, is why, even without the case management point, it wouldn't be an abusive collateral attack at all in any event. And we start, of course, here from the proposition that we've established that, in general, it's not an abuse to invite an inconsistent finding, a finding inconsistent with an earlier decision, which is not binding between different parties. And it's for the applicant and PwC to identify some special reason why the administration of justice is brought into this repute. Now, here, before getting into that directly, I'm afraid we do have to pause and look into the question of the overlap between the two sets of proceedings. Because essentially, PwC's case is to say there was a near complete overlap. There is a near complete overlap between what we are inviting the court to do in our claim against PwC and the points decided by Mrs. Justice Rose in the first proceedings. And that's not right, and I need to explain why. Because if it's not right, then the application basically is undermined entirely. Now, we need to look, therefore, at the overlap between the two. So we need to understand, in my submission, what Mrs. Justice Rose actually decided, and also what is actually alleged in these proceedings. Because PwC's submissions in our respectful submission mischaracterise both. They suggest that the Rose findings were rather wider than they really were, and they also characterise the PwC claim as more narrow than it really is. So we do accept, we've always accepted, excuse me, that there is some overlap in the issues regarding, some of the issues regarding the broad question of compliance.
Well, you must do, because that was the basis of the previous submissions.
Yes.
So this is just degree of overlap. I mean, I'm not saying it's not important, but we can't get away from the fact that everybody agrees there's overlap.
Yes, exactly. Absolutely.
Well, the unlawfulness of the dividend and that the accounts didn't show a true and fair view, it is inevitably a substantial overlap, isn't it?
It is a substantial overlap, my lord, yes. But it's not nearly as substantial as PwC suggests. And I'm going to go and explain that now.
Okay.
Now, the issues are wider in these proceedings for several reasons. And the first one is the point just alluded to by my Lord, Lord Justice Flaux. Because in fact, the issue on which Mrs. Justice Rose ruled was relatively narrow. Because what she was dealing with was the issue of the lawfulness of the dividends, and therefore whether there was any non-compliance in the accounts with the statutory requirements which rendered those dividends unlawful. And it's very important because not all non-compliance would have that effect. And for this purpose, we do need to look, actually the provisions, if we may, at Part 23, my lords, because the court's not been shown those, but they're the critical provisions, certainly for the first proceedings, but also for the second. So we've got the statutory provisions, my lords, in the first tab of the first authorities bundle.
They're also in the appendix to Mrs. Justice Rose's judgment.
Yes, it might be, yes they are, my lord, yes, absolutely. It might be slightly easy to look at them here for a particular reason,
Okay,
because
fine.
Annoyingly we were subject to the transitional provisions.
Okay.
Because the accounts, relevant accounts were prepared under the 1985 Companies Act provisions. And of course, by this stage, we just moved on to Part 23 of the 2006 Act as regards the question of lawfulness of dividends. So we straddled the two regimes. My lord, could we just first look at paragraph 235 of the 1985 Act, which isn't in the appendix to Mrs. Justice Rose's judgment. That's about 6 pages in. Annoyingly, these aren't numbered. 6 pages in the first tab.
Auditor's report.
Yes, exactly. Now, this is important because it identifies what the auditors had to state under the statutory regime which applied to actually both the 2007 and the 2008 accounts. So 1B in particular identifies that the report must state clearly whether in the auditor's opinion the annual accounts have been properly prepared.
So this is section...
Sorry, my lord, section 235 of the 1985 Act.
Yeah.
which, as I say, govern
and it's section
subsection
1B.
1B identifies what the auditor's report.
One capital B, not one little b.
Sorry, one capital B. The report must state clearly whether, in the auditor's opinion, the annual accounts have been properly prepared. These are very important words, in accordance with the requirements of the Act. And then 2, the report must in particular state whether the annual accounts give a true and fair view in accordance with the relevant financial reporting framework. So there are 2 requirements here. There's the properly prepared requirement, and there's the true and fair view requirement. And in our submission, the true and fair view requirement is a subset of properly prepared. And one can see that also when we look in a moment at Part 23. It's quite important because EWC submissions all along focus on true and fair. But it's not just true and fair that was relevant to the task the auditors had and the opinion they had to express. And properly prepared is obviously wider than true and fair. And in particular, we say that it includes matters of process, and if there's any doubt about whether disclosure matters come into true and fair, they most certainly come into properly prepared.
Now, this page seems to suggest that this was the form of the section between the 1st of October 2007 and the 5th of April 2008.
Yes, but
am I not right in saying the 2007 accounts were prepared at a later date?
It applied to accounts which were prepared during in relation to a period which included.
So, in other words, this section would continue to apply to accounts where the accounting period terminated before the 5th of April 2008. Is that your point?
My lord, yes, exactly. So both the 2007 and 2008 accounts were covered by this. I think that's common ground, and there certainly wasn't any debate about that in the Sequana proceedings.
And the accounting periods remind me they were with calendar year end, is that right?
They were, yes.
Yes.
Exactly. So that's the auditor's report. Then, if one goes on to tab 2 in this file, my lords, there's Part 23 of the 2006 Act, which governed lawfulness of distributions, is taken from the Butterworth Company Law Handbook. Excuse me, because what it helpfully does is to set out the transitional provisions and their effect. So I'll just quickly take my lord through this, if I may. 829, section 829 deals with the meaning of distribution. And while we're on this page, the note immediately under deals with the effect of the transitional provisions. And the important bit here is one goes to paragraph, sorry, the numbering hasn't been copied very well, but it's 35 sub 1. Relevant accounts for the purposes of chapter 2, part 23. In relation to maybe accounts for financial years beginning before the 6th of April 2008, in which case the provisions of the 1985 Act apply. And then sub 2B in section 837, which is a key section here, little Roman 3, in subsection 2, for this Act substitute the Companies Act 1985. And just, we'll look at that section in a moment. That just makes it clear that properly prepared in accordance with the Act, the 2006 Act, is substituted for properly prepared, or with properly prepared in accordance with the 1985 Act, where it's the 1985 Act which actually governed the relevant accounts. So it's just a transitional provision dealing with the little glitch that arose. So if we can then go on to section 836, my lords, 836, 837 and 838 are the crucial provisions here. 836 identifies how one determines whether there are sufficient distributable profits to render the dividend lawful. Section 830 has provided a distribution may only be made out of distributable profits. And Section 836 tells one how one works out what distributable profits there are, and says that it must be determined by reference to the following items in the relevant accounts. Subsection 1, and that's profits and losses, provisions of various kinds. And then importantly, subsection 2 identifies what the relevant accounts are. And they are the last annual accounts, which will be defined in a moment, except where the distribution would be found to contravene this part by reference to the last annual accounts, in which case it may be justified by reference to interim accounts. So there are two possibilities: last annual accounts, which are basically the last statutory accounts, and alternatively, if those don't show available profits, one can rely on interim accounts. And then Section 837 identifies the requirements for last annual accounts. And it first just confirms what that means. The company's last annual accounts are the company's individual accounts last circulated to members as required under the statute. So it's the last statutory accounts. And very important, subsection 2 of 837. The accounts must have been properly prepared in accordance with the 1985 Act under the transitional provisions. The words "this Act" being substituted with 1985 Act in those provisions I showed you a moment ago. These are very important words. Or have been so prepared, subject only to matters that are not material for determining, by reference to those items set out in 8361, whether the distribution would contravene this part. So prima facie, they've got to be properly prepared, but there's an exception that applies if they're not properly prepared, but in a manner which is not material to working out what the distributable profits are. Just putting it very broadly. And that's a provision that explains some very important findings by Mrs. Justice Rose, which I'll come to in a moment. Now, the other important point is that subsection 3, unless the company is exempt from audit, the auditor must have made his report on the accounts. So it requires the accounts to have been audited and for there to be an audit report. And subsection 4, if that report was qualified, the auditor must have stated in writing whether, in his opinion, the matters in respect of which the report is qualified are material for determining whether a distribution will contravene this part. So there are two requirements. The accounts have got to be properly prepared, subject to that materiality exception. They've also got to be subject to a clean audit opinion, subject only to the exception of the auditor certifying in writing that the qualification isn't material. My lords, just for completeness, if one goes over to 838, one sees the requirements where interim accounts excuse me, are used. Now, that's a rather less precise requirement. It's that interim accounts must be accounts that enable a reasonable judgment to be made as to the amounts of the items mentioned in 8361. Now,
does the fact that 837 subsection 2, under the transitional provisions, says that the accounts must be properly prepared in accordance with the Companies Act 1985, that brings in the true and fair requirement, does it?
Absolutely, absolutely. That's
because this section doesn't refer to
no, exactly. But that's a critical element of being properly prepared in accordance with the Act, because that's a requirement.
And that's the same that although it's not referred to expressly in this subsection, it would be the same position under the 2006 Act, presumably.
Both the 2006 Act and the 1985 Act require in terms that the accounts be true and fair, yes.
Yeah.
Not just indirectly through that provision I've just shown my lords in relation to the auditor's opinion, but directly. I don't think there's any debate about that.
No, I just
Find the
wanted
provision
to be,
necessary.
I was slightly puzzled by the fact that this particular piece of drafting, that was all.
Yes.
Yeah, okay.
It's simply what's required for section for part 23 is that the accounts are properly prepared in accordance with the Act. So that's basically all the requirements that the Act brings in, and that includes the true and fair requirement.
Yeah.
And as I say, in relation to interim accounts, the requirement is a little more flexible. Significantly, in this case, for what it's worth, eventually, the Sequana defendants conceded that actually, in this case, for the interim accounts in December, the true and fair requirement applied. There was no difference in this case. It was quite important that it was in this case between enabling a reasonable judgment and showing a true and fair view. Nothing turns on that for present purposes, but just to explain. So, very importantly, therefore, applying those provisions, what Mrs. Justice Rose actually decided was that the figure for the provision, so the end result, was in her view true and fair. And she held that the other complaints we made as regards the accounts not being properly prepared did not render the dividends unlawful. In relation to disclosures, my lord, she did that expressly by reference to section 837, subsection 2, the materiality exception, which I've just shown my lords, holding that if there wasn't an adequate disclosure, that wasn't material for that purpose. Which is why, in relation to the Fox River disclosures, she made no findings as to whether they were adequate or not. She held they just didn't matter, because they didn't, even if inadequate, as we alleged, render the dividend unlawful. She also, importantly, held that as regards matters of process, a defect in the process by which the provision was arrived at was not material, did not render the dividends unlawful. My lords have seen paragraph 831 of my lady's judgment, which just came to that conclusion. Now, it's absolutely fair to say it is not put expressly in terms of section 837 of section 2, but it's our contention that's the only sensible explanation of that finding. Because if accounting principle requires a process to be adopted, such as the pertinent question there, independent legal advice, then the accounts are not properly prepared in accordance with the Act.
Sorry, which paragraph?
Sorry, this is if one goes to 381.
381.
Yes.
Sorry, I think you said 831.
I probably did, I'm
Yes,
sorry.
long though it was, I think it might reach
I apologise.
the 800s.
Transposing the...
381.
Yes, if one goes to the... This is page 623. It's probably worth a look. It's under the heading at the top of the page, a duty to obtain professional advice. I'm going to come to this in a moment, but there was an awful lot of common ground between the accounting experts in that trial as to what was required. I'll come to that in more detail in a second. But we were contending, supported by the accounting evidence, that what they needed to get was independent legal advice, so US legal advice, as to what the likely outcome was, putting it very broadly, of the US litigation, which was ultimately going to determine what the quantum of the liability
Sorry,
was
and
going to be.
just so I understand, your point here is that although she doesn't spell it out, what she must have had in mind is that this fell within the, as it were, the proviso in section 837 subsection 2, even if they're not properly prepared, if the defect is not material.
Yes, precisely so. Yeah. She expresses herself in 381 at the bottom in her conclusions in more wide terms. I fully accept.
Yeah.
But actually, the only explanation for that has to be section 8372, because, and she does refer to section 8372 when she's dealing with the non-disclosures point later on.
Yes. So, I mean, putting it crudely, the effect of 8372 is it's the bottom line that matters. If that is true and fair, then defects in the process by which you got there aren't going to invalidate the accounts for the purposes of distributing dividends.
Yes, I mean that's certainly the view that Mrs. Justice Rose came to. I'll probably best reserve my position as to that going forward, but that's for present purposes, that's clearly the view that Mrs. Justice Rose came to. And all we're concerned with here is just trying to identify what she decided and the scope of that and how that compares with what we're now contending. I said there was a lot of common ground amongst the experts. Obviously, that's not going to bind anyone now, but it is significant in showing that this is not a fanciful case on our part, because Mr. Lloyd sets this out in particular in his statement, particularly at 284A, which is at page 823. It starts at 822 and goes over to 823. And it's really the middle half of the page on 823, where what he's doing in these paragraphs, my lord, is setting out, explaining our case, but in so doing he refers at various points to matters that were common ground between the accounting experts in the sequana proceedings. Not, as I say, because it binds anyone, but because it indicates this real force in this. So they agreed that if accounts weren't prepared in accordance with accounting standards, they're not properly prepared, and save in exceptional circumstances, they're not true and fair either. That's actually simply reflecting matter that the courts have ruled on various occasions, based originally on famous joint opinion by Mr. Hoffman QC, as he was at the time, Miss Arden, as she was at the time, back in 1983, expressing the view, which has now become accepted as commonplace, that prima facie, if you don't comply with accounting standards, the accounts aren't true and fair. It's only prima facie because the true and fair requirement overrides everything, but that's the starting point.
Yeah.
And they also, as Mr. Lloyd explains here, agreed that compliance, in order to comply with FRS 12, there had in this case to be independent legal advice. So there was a lot of force in this. I should emphasise, let me just deal with one point very quickly in passing. It's legal advice here that's required. I know your friend referred to advice from PCC. The Lords may remember this. It's referred to in a note in the accounts in paragraph 437 of Mrs. Justice Rose's judgment. Just look at it. It's in the same file. It's page 628. He was suggesting, my friend was suggesting, that this. It's not right. Apologies. 437 is right. It's 638. It's the note in the 2008 accounts, which says, for the purpose of creating its reserve, the company, using third-party experts, notably PCC, has taken a reasonable, prudent view as to API's likely share of the cost of remediating the remainder of the river. Well, we actually attack that note as being thoroughly misleading in the amended points of claim. My Lord's note, paragraph 195.6, because PCC did was simply to advise on the numbers, in particular the total possible remediation costs, not the share at all. What was required in relation to the share, most importantly, was independent legal advice as to what was going to happen in the US litigation.
Sorry, could you just remind me who PCC are?
Well, PCC were a company that they crunched the numbers, basically, trying to work out, advise, what the range of possibilities were as regards the total remediation costs.
What was their professional expertise? I mean, what kind of experts were they?
Not quite sure how they characterised themselves, my lord. I'm sorry not to be helpful. They weren't accountants, they weren't lawyers, they were number crunchers.
Fine.
The judge
I'm sure it's explained somewhere. It's just, as
Yes, I'm
always,
sorry, it is, and I'm sorry.
as always, acronyms leave me puzzled because unless you have a glossary at hand, it's not
Well, I'm sorry. Well,
impossible to work
they-
out who's being referred to.
No, I have every sympathy. But the point for present purposes is PCC don't really feature in this story at all. And the point is they're not legal advisors.
I see.
And I was suggesting that they were, or that was
No, sir, I did not suggest they were. I suggested they answered the description in Mr. Lloyd's witness statement, which they did.
I'm grateful.
Where's the paragraph in the judgment where the judge describes PCC?
Paragraph 108.
Thank you. I'm grateful. I think that answers my lord's
I'm sure it will
query.
if we can find it.
Project Control Companies, Inc.
Thank you.
And as is described, what they deal with is the remediation costs. Because, as my lords will appreciate, I hope the provision involved, amongst other things, working out what the range of possibilities were as regards the total cost of cleaning up the river, and then trying to work out what the range of possibilities were as regards the share of that total cost, which would eventually, after all the litigation had run its course, end up in the lap of NCR and API. Because that was where the company's liability indemnifying API came from. Now, so, in short, Mrs. Justice Rose made a ruling as regards the figure, the ultimate outcome, the bottom line, as regards the provision, but not as regards the process, because she said that didn't matter, for the purposes of the question in front of her. Nor did she rule on whether the disclosures in relation to the Fox liability were compliant. Very important to distinguish Kalamazoo and Fox here, because there were two disclosure complaints. One was in relation to the Fox River, and one in relation to Kalamazoo. As my lords will appreciate, they're totally different liabilities, different sites. In relation to Fox, there were disclosures, but we say they were highly inadequate. And that disclosures were required under FRS 12, both in relation to the provision figure itself and in relation to the contingent liability that existed over and above that. And FRS 12 requires disclosures on both. Now, as I think the laws have probably seen, Mrs. Justice Rose decided, this is paragraphs 440 and 4 to 442, at page 640, that if there was a failure to make adequate disclosures, it didn't matter for Part 23 purposes and the lawfulness of the dividend. And she did, as one sees from the middle of the bottom half of paragraph 440, expressly refer to section 8372 in that respect. So she didn't make any findings about process and didn't make any findings about the adequacy of disclosures. And again, as regards the disclosure, there were strong elements of common ground between the experts, as Mr. Lloyd also explains. They agreed that the disclosures in both the 2007 and the 2008 accounts failed to comply with FRS 12 in at least some respects. And that's Lloyd 283B at page 820 and 284F at page 828. And that a failure to make those disclosures would or might lead to the accounts not being properly prepared and not showing a true and fair view. And that's Lloyd 284F at 828. So Mrs. Justice Rose did not decide the question of whether the 2008 accounts, or indeed the December interim accounts, showed a true and fair view and were properly prepared. She decided the question of whether they showed a true and fair view and were properly prepared sufficiently for the purposes of Part 23. So those points we now pursue in relation to the process and disclosure are not points of overlap. They do not invite decisions inconsistent with the findings of Mrs. Justice Rose. I'll come back and deal with the Kalamazoo position differently because there are various points on that. Now, the second reason why the overlap is not as great as suggested by PwC is that the issues are wider now because we raise new points that were not in front of the court in the first proceedings. Now, some of those don't even relate to whether the provision showed a true and fair view. And in particular, there is the going concern. Some, however, do relate to whether the provision was true and fair. But they're entirely new points. They were not in the first proceedings. I'll just list them out here. And if necessary, go on and explain them. There's the, my lords have probably heard reference to these, but there's the OU1 point. There's the 100% point, which I will need to explain. There's the modelling errors, my lords have heard reference to. There are the 2007 accounts. So the new issues are not limited to those referred to in the appellant skeleton at paragraph 39, for example. Now, I'll explain those new points in a moment, but just before doing so, it's also important that, as Mr. Justice Fancourt noted, these issues are going to be determined, all of them, the new ones and the area of overlap, in a different context. Because here we're primarily concerned with compliance by PwC with its duties and the effect that compliance would have had on the accounts and on the director's conduct. So the information that's relevant is not just the information the directors actually had, but also the information that they should have got that was reasonably available, which they should have got prompted by the auditors doing their job properly.
In relation to impact on directors' conduct, I mean, that's an aspect of the case that's going to require the calling of the directors to give evidence, isn't it?
Well, I'm going to explain it in a minute our attitude to the directors.
I mean, I understand your point, that, at least I think I understand your point, which is that if you say, if PwC had complied with their duty in full, they would have qualified the accounts, or they would have required other things to be done, further disclosures, for example, further disclosures, which would have put a different complexion on matters. But whether that would have led the directors not to agree to the dividend, it depends upon the directors' evidence about that, doesn't it?
Well, yes. Now, in relation to the director's evidence, can I just deal with, maybe helpful to deal now with one point. We don't challenge nearly everything that the directors said. We're not going to challenge nearly everything the directors said in the first proceedings. My only friend suggested what this will involve is an attack on the credibility of the directors in these proceedings, or he suggests it necessarily has to. It doesn't, and it won't. I will have to elaborate this in a moment, but we're not going to attack the director's evidence. To a large extent, the director's evidence as to what they in fact thought and did is going to be the stepping off point for our claim here. Now,
I thought my Lord's question was more as to the counterfactual.
Oh, indeed. I'm sorry. I'm not ignoring that, my Lord.
Right.
It's the counterfactual that interests me, as
Yes.
my Lord says.
So the starting point is what they actually did and thought.
Yeah.
Because
you have to be able to establish, don't you, that they would have done something different.
Well, let me explain how we say the causation question operates.
Yeah.
The first point is that you simply can't pay a dividend if you're not allowed to under Part 23. So to the extent that the audit opinion was wrong in saying that the accounts were properly prepared, and in fact the accounts should, shall we say, have shown a very large provision, very much larger than shown, then to that extent the dividend simply couldn't be paid. And there isn't really much of a counterfactual there, because to that extent it couldn't be done.
But that involves it involves at least a collateral attack on Miss Justice Rose's findings. Probably involves a direct attack on them, actually. Because none of that runs, does it?
Yes.
I'm not saying you can't.
No.
You're right about your point about the procedural shenanigans, if I put it that way. Then none of this matters in one sense, because that's why I put to you the point about collateral attack.
Yes.
But if what you're saying is, well, you can't pay a dividend if you're not allowed to under Section 823 because the accounts should have shown much larger provision, that runs directly contrary to the findings that were made at the first trial.
To the extent that finding that the provision was too small is based on the same points that were actually adjudicated by Mrs. Justice Rose, then yes, I have to accept it. But as I've indicated, there are further reasons why the provision was wrong. The new points, if I can just use shorthand for a moment. But that's the first step. Now, even if the defects in the accounts, which ought to have led to the opinion being qualified, shall we say, did not prevent a dividend being paid, then that's where the counterfactual comes in. I mean, the first point is that it would certainly, the defect in the accounts, which would have required a qualification, would certainly have stopped that particular dividend being paid. One's seen the effect of Section 837, subsections 3 and 4 in particular. So for example, if there had been a lack of independent legal advice and the auditors had spotted that and said, no, you must go and get this advice, then they would not have given an unqualified opinion until that advice had been obtained and taken into account. And the dividend simply therefore couldn't have been paid because they certainly couldn't have given the certificate under subsection 4 the statement that actually the defect, the qualification was immaterial until they'd seen what the advice was. It's not just a tick box, you've got to actually take the advice and take it into account. So they certainly wouldn't have been able to actually pay the dividend they paid. So the counterfactual involves two things. First, what objectively should the accounts have shown? Now, that doesn't require the director's evidence. Then the second element of the counterfactual does require, or at least it requires one to look at the evidence at least that was given in the first proceedings by the directors. And that is what they would actually have done in accordance with their fiduciary duties in terms of paying another dividend. I don't want to digress onto this too long, but my lords will have seen that Mrs. Justice Rose found, and I don't think there's really any doubt about this, that what they were trying to do was to get rid of the intercompany debt completely so they could sell, Sequana could sell the company to Messrs. Gower and Tauscher, two advisors. And so if there was even a requirement of a small provision, that would have meant they could not have eradicated the intercompany debt by paying a dividend. There's a real question as to whether they'd have paid any dividend at all in 2008. Because, of course, the whole purpose was, as Mrs. Justice Rose found, to get rid of the intercompany debt. If they couldn't do it, well, they might not have made any dividend payment at all. They might have done, they might not. And that's where things such as the disclosures, particularly as regards going concern, for example, would potentially make a huge difference. Because if there's not some great prize to be obtained in the form of the ability of Sequana to sell the company, it's just a question of whether to pay a dividend or not. The directors might well have said, well, we're going to be a bit more cautious here, particularly in the face of this advice from the auditors, that there's a material uncertainty as to going concern. So yes, there is a counterfactual, and I fully accept, ideally, we would have the directors present also in the trial of these proceedings to give further evidence. We may, or depending on what happens, of course, we're still litigating against them in the Supreme Court.
Well, in a sense, if you're right about all this, it just shows what an unmitigated disaster it was agreeing that consent order 5 years ago. Because the idea that these directors are going to be hauled along again to be cross-examined yet, well, not sure what's going to happen. You'd have to get them to agree to give evidence on your behalf, and then, which they may or may not do, and you'd have to get them to agree to provide witness statements saying what they would have done, on which Mr. Salzade will cross-examine them at great length as to why they wouldn't have done that. They'd have done what they did do.
If they're prepared,
all of which should have been explored in the first trial.
Yeah.
If they don't give evidence, we will simply invite the court to accept the evidence that they did give in the first trial on a hearsay basis, and PwC can make whatever submissions they like about the weight of that. But it will, we would suggest, be accepted by the trial judge, and will form the foundation for the counterfactual exercise. Now, the counterfactual exercise would entirely be much easier if one also had the directors giving additional evidence, speculating as to what they would have done in different circumstances. But having said that, in our submission, it wouldn't actually improve the position hugely. It's not terribly helpful in reality when directors or actors along and give evidence as to hypothetically what they might have done in different circumstances.
Well, in a lot of professional negligence actions, the counterfactual and evidence as to what the claimant would have done had the proper advice been given is absolutely critical. Yeah. It's an essential aspect of the case. So saying, well, it won't actually make any difference, I'm afraid doesn't impress me, at least.
And you've got to establish it, I mean, to the civil standard of proof. You've got to persuade the court that there is a better than evens chance that they would have done X rather than what they did in all those years ago.
Yeah, I'm not suggesting it wouldn't make any difference, but it will be manageable, although difficult without it, is what I'm suggesting. And of course they may, depending on what happens in the litigation continues, they may come and give evidence for us. And it won't be evidence that involves going all over what they've said previously, because there's unlikely to be any challenge to that. It will be evidence focused narrowly.
But equally, I mean, just I'm sorry to press you about these things, Mr. Johnson, but speaking for myself, I don't find any of this very easy. But if one just goes back to your point about the legal advice, I mean, true it is they didn't have independent legal advice, but they had a whole load of legal advice, including from Mr. Bates, about, for example, the effect of Burlington Northern. You'd have to be able to demonstrate, wouldn't you, that if they'd gone off and got independent legal advice, that legal advice would have been different from the advice they were getting.
Yes.
And that's again part of the counterfactual. And that I can see all sorts of problems with getting a lawyer to say that what the position would have been in early 2009 in light of what's actually happened.
Well, can I? Yeah. Well, I completely understand my Lord's starting point on this. But can I just develop this a bit further, because this is very important. In relation to the provision, the quantum of the provision, which is what the legal advice was needed for, let's take 2008 and Burlington Northern in particular. Now, what FRS 12 actually requires, and again this was something that was common ground between the experts at trial one, was that what you've got to do in quantifying your provision is not just look at the most likely outcome. And that's in particular paragraph 40 of FRS 12. What you've got to do is you've got to take account of other possible outcomes, particularly if they are more adverse. And this was a classic case for this because the uncertainty was huge. The range of possible outcomes was enormous. And there were clearly alternative outcomes, which might not have been the most likely. But the most likely outcome wasn't especially likely, if I can put it like that. It may have been the most likely, but it wasn't especially likely. Now, specifically in relation to Burlington Northern, and my Lord Justice Flaux's question there, what happened was that the directors took a particular view of the effect of Burlington Northern, which came out just before the second dividend was paid. It was, we say, a rather extreme view. Essentially, that it completely changed the likely outcome in the Fox River litigation. And that was a view that, in a very rough initial bit of advice, was expressed, and it was run very hard with by Mr. Gower. And Mr. Gower obviously was highly conflicted because he wanted to buy the company from Sequoia, which was only going to be possible if the provision could be reduced enough to allow the dividend to be paid to get rid of the intercompany debt. Now, it is evident on the facts as found by Mrs. Justice Rose that the directors only took account in reaching that 38% share figure of their view of the effect of Burlington Northern. And that's paragraph 411 in particular of Mrs. Justice Rose's judgment. And it's also apparent from Mrs. Justice Rose's file there was recognised at the time an alternative view. I emphasise at the time. Sidley Austin, who were the lawyers for NCR, my lords will appreciate NCR and API were hand in glove on this. They were treated as just one party effectively by all the other parties in the government. Their view, as they expressed at a meeting at the time, was that Burlington Northern didn't really make any difference. Now, if you're looking for the most likely outcome and you think that's the effect of Burlington Northern is radical in relation to Fox, then you may well come to the 38% figure. But FRS 12 requires you not to just do that, but to think about the alternative, which is that Burlington Northern doesn't really make any difference. And that therefore, you're still staring down the barrel of 100% liability.
I appreciate the point. But going back to what I said earlier, that involves a wholesale attack on Mrs. Justice Rose's findings in relation to the second dividend, doesn't it?
It involves inviting a different conclusion.
Well, but that's a polite way of putting the same point.
Well, my lords will hopefully forgive my slight evasion, but it's not forensic. There's a little bit more to it because Mrs. Justice.
Well, you're saying she should not have accepted that 38% was the best estimate.
Absolutely.
She should not have accepted that the absence of legal advice was not material. She should have accepted that the absence of disclosures was not material, and so it rolls on. I mean, that's in effect.
Yes. On this point, it's the absence of legal advice. But yeah. What we're not doing is inviting a completely different set of findings of fact. Because what we're basically saying is, with great respect to the judge, she got FRS 12 wrong. I'm not here to criticise the judge, but to this extent we say she got FRS 12 wrong because she found in terms that the directors only took account of one view of Burlington Northern. She also, when she set out FRS 12, she did in fact miss out that critical paragraph 40. So it appears that she didn't apply FRS 12 as we say she should have done. And of course, the trial judge, these proceedings may agree with Mrs. Justice Rose, but it's at the very least a perfectly tenable view, backed up by the views of the accounting experts in the Sequana proceedings, that's what you've got to do under FRS 12. And as a matter of fact, it's absolutely plain from the judge's own findings that that's not what the directors did. So, just on the counterfactual on that isn't that complicated, because if the independent legal advice should have said, there are two views about Burlington Northern, on one, it doesn't make any difference to your case at all, then applying FRS 12, they clearly had to increase the provision. Now, by how much would depend on what the advice was.
If you're saying the judge was completely wrong in her approach to FRS 12 on this issue, I mean, that really is a straightforward head-on collateral attack on her view of the law in a case which you yourself took to the Court of Appeal and appealing to the Supreme Court. So, although not on that point. So that is really fuel to the abuse argument, isn't it? This really is having a second bite at that particular important part of the judge's legal analysis.
But that's exactly what, as in the Oceanus case, for example,
yes,
is contemplated as being...
Well, you're absolutely right. I mean, it comes back to the point about the case management.
I think when it comes back, everything seems to lead back to that.
At some point, are you going to take us to Oceanus? I mean, I was in that case as well, but even longer ago. And all I can remember really is the famous Purple Amendment, which was something to do with C.E. Heath, but that's about all I can remember.
Well, the facts are very different. It's the point of principle, which I think we relied on. I don't think they may be. But I think I read a passage from Lord Justice Carr's judgment where he accepted that if you're in the undesirable position where there's going to be a second trial.
The point I've got slightly different, but the point I've got in mind is that the extent to which the second set of proceedings involved effectively an attack on the conclusions that have been reached by Mr. Justice Lloyd in the CCI v. Oceanus, the first case.
Okay,
and,
well, I'll have a look and see if I can help on that.
I mean, it was very complicated. My recollection is it was an application for permission to amend the defence to raise a whole load of issues on which they'd lost before Mr. Justice Lloyd.
Yes, exactly. So it was a
so there was an element of collateral attack.
Yes. And in Wilson, there's a head-on attack because basically it's a bribery claim, and in the arbitration proceedings, it's decided as between the company and the fiduciary who's alleged to have taken the bribe, that in fact there wasn't a bribe. And then in the litigation that follows, which is unsuccessfully alleged to be an abusive collateral attack, the company pursues a knowing assistance claim against the defendant who's accused of having assisted the bribe, which necessarily involves proving that there was a bribe. Yeah. And that is not an abusive collateral attack, says this court, with respect to clearly rightly. Yeah. So the fact that you end up inviting an inconsistent decision, yes, is inevitably part of this. If that were not the case, we wouldn't be here at all. There wouldn't be any possibility of accusing us of abusing the process. The point I was alluding to in relation to Bragg and Oceanus was that in the passage I read from Lord Justice Carr, he accepted that if you have a second trial, it may well take a totally different course with different witnesses in front of a different judge, and that is, as Lord Hoffman observed, and I think Lord Hobhouse as well, in the Hall and Simons case, it's not impossible to have irreconcilable judgments. This happens. The question of whether it's an abusive collateral attack if one is inviting the court in the second proceedings to do that. So it's not enough. It's not enough that we are going to be inviting the court to be.
Well, I think that's common ground.
Yeah.
Yes.
Because it's not the same parties, so it's not issue estoppel or res judicata.
Yes, exactly. And what I'm really saying in response to my Lord's question is that yes, we're going to be inviting a different conclusion. I'm trying to explain why how exactly it's different, and how we're going to be inviting the difference. And it's not coming along and challenging all the findings of fact that the judge made. Largely, it's a matter of accounting principle, and then expert US findings that the judge never made because she found that they weren't really germane.
Well, is it perhaps another way of putting it to say you're not likely to be challenging to any great extent the findings the judge made on the evidence before her? You will, of course, be asking the new court to make entirely different findings of fact as to what the directors would have done in the counterfactual.
I'm most grateful. That's a much more accurate way of putting it. But yeah, yes, what I'm really saying is that we're not going to be coming along and inviting completely different findings of fact on the points on which the judge made findings of fact.
Yeah.
So it's not that sort of, it's not a Lang type of collateral attack where you're coming along and saying, right, we just invite the second judge to come to a completely different view.
It's not a rehearing of the same evidence, inviting the court to reach a different conclusion.
Exactly.
That's the point.
Exactly. So all I'm really trying to do with this overlap, I'm sorry I've gone on.
So it's not saying that when the directors said what they said, they were not telling the truth. That's not your case.
No, it certainly isn't.
What you're saying is that if this additional information had been available to the directors, they would have behaved differently.
Yes.
In broad terms.
And part of that is we're going to be saying that one of the things the auditor should have been doing is directors on the shoulder and saying, well, you need to get this because otherwise we can't give a clean audit opinion. My learned friend keeps saying, oh, well, the auditor's role is terribly narrow. It's just to audit the accounts presented to them. We all know that in reality it's an iterative process.
Yeah. But equally, the question of what the directors would have done, I mean, it's not an objective question. It's a question of what these particular directors would have done with the benefit of all this additional material they should have had but didn't have. Is that right?
As regards the question of exactly what they would have done in accordance with their fiduciary duties, yes, I entirely accept that. As regards what the accounts should have shown, well, no, that is an objective.
That I agree is objective, yes.
So if
yes, but I mean, I was really saying you do still have to focus on these particular directors with their own agendas and interests which have to be taken into account and so forth.
Yes, so if on the 2008 accounts, for example, the court accepts that the effect of taking independent legal advice and understanding or taking into account the alternative view of Burlington Northern would have been a provision of over 135 million euros, then clearly no dividend could have been paid. So there's no need to worry about the counterfactual.
And I suppose you can rely upon the fact that Mrs. Justice Rose found that they were honest
we do.
directors who were not hell-bent on selling the company at any cost. So you can say, well, if the auditors had qualified the accounts in the way in which you say they should have done, then these directors would have behaved differently on a balance of probabilities.
Absolutely.
Even if you don't have them available to give evidence about that.
Absolutely, my lord. And that's the point that my lords have seen Mr. Justice Fancourt refer to in, I think, paragraphs 105 and following of his judgment. They were acting conscientiously on the basis of Mrs. Justice Rose's findings, and we certainly don't disagree with that. And therefore, you can't say, said Mr. Justice Fancourt, that they would have ignored further information or information from the auditors. I mean, as regards qualification of the accounts, they'd have had no choice.
Yes.
But if we're talking about the rather softer things, such as the disclosures, for example, regarding going concern, then they would have had a choice. We say they would have acted conscientiously.
Yes, I see that. Mr. Thompson, might that be a good moment for us to have our morning break? I wonder how long our shorthand writer would like us to have. You okay? Did you want any break at all, or are you happy to go on? In that case,
Brilliant.
Thank you. In that case, let's go on.
Thank you very much. Fantastic.
Yeah.
Right. So, I've slightly veered off course. I hope in a helpful way ultimately. As I indicated, my point is to really just establish the rather more limited nature of the overlap that we accept exists. Now, can I just, in relation to some of these new points, can I just clarify one point? The 100% point. Now, I think perhaps strictly speaking, there are 2 points that couldn't be called the 100% point, confusingly. I just want to make it clear what I'm talking about. Talking about a contention which we were not able to make former Mrs. Justice Rose. that the effect of FRS 12 is to require, in this situation, provision for 100% of the liability. Because what it requires you to do, where you are liable in full, but have the hope of reimbursement, is to provide for 100%, and then only recognise the reimbursement claim as an asset if it's virtually certain, which is the usual approach to a contingent asset. Now, confusingly, FRS 12 also has a provision that talks about joint and several liability. It says, although what I've just described is the norm, clearly, describes liability and seems to suggest there that what you might do is to simply make a provision for what you think you're actually going to have to pay yourself, and to the extent the other jointly and severally liable parties you think will pay, you just include a contingent liability. Now, I can take my laws to the relevant provisions of FRS 12 if it helps.
No, they're all set out in the judgment, aren't they?
No, they're not, because this wasn't the point that was in front of me. Oh, well, no, they're not actually on this, because this wasn't the point. Perhaps I should...
No, I meant Mr. Justice Fancourt's judgment.
I'm not sure, to be honest. I'll check. I'll check. But
It's all right, it's not a memory test.
the point is here. This is a question of pure accounting principle. And it may well be that accountants differ on it. Well, we know they do to some extent because the evidence before Mrs. Justice Rose was that what they did was okay on this. But we couldn't run this point. Now, supported by our expert, and as pleaded in our amended particulars of claim, we say that is actually the effect of FRS 12. Now, we accept it's a difficult point, because ultimately it turns on, juridically, what's the nature of the liability here, where NCR and API are liable to the US government to just pay all the costs. And what they've got to do is they've got to go and make contribution claims, as they'd started to do, against other parties. Does that fall within the joint and several liability paragraph of FRS 12, or does it fall within the reimbursement paragraph? We say the reimbursement paragraph. So actually what they needed to do was put in 100%. Now sometimes they do get described, these various parties in the litigation, contribution litigation, as jointly and severally liable. That's not really strictly correct. It's quite a difficult question of US law. One of the reasons it's not is that if the US government settles with one of them, it drops out altogether, and the others can't make, who are still in the frame, can't make a contribution claim. So it isn't really like joint and several liability. So this isn't just a semantic point, it's actually quite a...
No, I mean, in our terms, that's joint liability as that result. And that's the whole point of the difference.
Yeah.
Yeah.
So it's quite... So I emphasise that, that's the 100% point. Now, there's another way in which, in fact, there could have been 100% liability. And if one hears Mrs. Justice Rose talking about 100% liability, it's this that she's talking about. Because the other way in which there could have been 100% liability would have been if, in fact, all the contribution claims that API and NCR were making failed. And that's exactly what happened in December 2009, only a few months later. Because my lords will have seen reference to the case management order of September 2008, where the presiding judge, Judge Griesbach, docketed to the case, directed that there should be a trial of a preliminary issue of basically knowledge of the polluting effect of the PCBs. And the problem was that NCR was the one that was really in the frame there, because NCR had been producing its paper since the 1950s using PCBs, and had been at the heart of the process, and there was documentary evidence that it may have known rather sooner than it let on that there was a problem. So the danger was that the effect of the December trial would be that the judge would find that NCR knew far more than everyone else, and therefore was 100% liable. There were no contribution claims, which is exactly what he did decide in December 2009, sorry. Although I fully accept that was then appealed and it got a whole lot more complicated. But that doesn't really matter for these purposes, because the point is that there was a real danger, which they really ought to have picked up.
But it's whether it was a contingency that should have been catered for in the accounts, effectively.
Well, and it should also have got, absolutely, but it should also...
And your point, as what I understand by this, is that your case is that they should in fact have made provision for 100%.
Yes.
Albeit that they could, the accounts could have said that, you know, there were hopes of reimbursement from certain quarters or whatever.
Oh yes, in fact, they definitely should have said that if that was the position. Yeah. But sorry, this
rather than saying we're at 60% because we've got a risk, we've got a 40% of it we'll get back from somebody else.
Yes, but even if I'm wrong on the effect of FRS 12, so they didn't have to provide for 100%. They were instead doing the share exercise that they were in fact engaged in. Well, even then there was a risk of 100% liability in fact, because of that could have been the outcome of the contribution proceedings. But even again, it comes back to the way in which one applies to FRS 12. Even if you don't think that's the most likely outcome, you've got to make provision for it. If you think this is relevant to the 2008 account, because even if you think 60% is the most likely outcome, if you're forced to recognise that while you think it's the most likely outcome, there's a real risk, say a 40% risk, a 30% risk even, of 100%, you've got what FRS 12 requires you to do is to bump that up to take account of the 100% risk. Not all the way to 100%. No. But you've got to allow for the fact that there's a 1/3 possibility, say, of being 100% liable. Because what FRS 12 expressly requires you to do is not actually to estimate the outcome. It's to estimate what should be paid to buy out the liability on the basis of the present circumstances. That's why paragraph 40 goes on to say, well, what you've got to do is you've got to take account of other outcomes other than the most likely outcome. Because what the liability should be bought out for depends on what the risks are overall, not just the risk of the most likely outcome. Lord, I can explain the other new points if need be. I mean, I don't know whether my lords have understood the OU1 point. That's an entirely new point. Wasn't in front of Mrs. Justice Rose. We tried to get it in. We weren't allowed because we made the application to amend too late. The danger of disclosure being required. That was purely a matter of fairness as between ourselves and the defendants to those proceedings. OU1 is the upstream. Yes. The operating units, the operable units were 5. And OU1 was the one that was upstream from the facilities that NCR had operated. And so it was liable potentially on an arranger basis for that. And it had paid some of the costs of cleaning that up, because that had been cleaned up. And so when it came to the provision had been made in the 2008 accounts, which attributed a 60 million figure to that liability. So the possibility that actually the relatively small contribution that NCR API had made to that actual cleanup would be found to be not enough contributions to others. That was the 60 million. And what happened in the 2008 accounts was that, sorry, the 60 million in the 2007 accounts was in 2008 taken out, so no liability in relation to that, and a credit of 10 million was then added in on the basis that they expected to be able to get the money that they'd spent.
That was on the basis of their reading of Burnington Law?
Apparently it seems yes.
The application to amend was when? During the trial?
Right at the beginning, well, early in the trial.
Early in the trial.
I'm not sure it was right at the beginning, it was early in the trial.
Okay.
I think it was being said against you that it would be an element of the overall abuse if you were allowed in a new trial to advance the OU1 argument when you'd actually been precluded from doing so in the previous one.
Exactly. It's definitely a new point. We can't be accused.
Well, I know, not just because it's a new point, but also because you were, you know, for reasons your own culpability for not having brought it in at an earlier stage. And it would be therefore abusive to let you get round that ruling indirectly in the second trial.
Well, I would, if I may, with great respect, challenge the culpability.
Well, maybe that was a
Well, no, I don't really understand why the point is made. I need to deal with it.
shorthand.
But an answer to that point is that it's an issue that arises in these proceedings which simply hasn't been determined full stop.
Well, exactly.
And as between you and PwC, the fact that you might have been blameworthy in some respect for raising it too late against Sequana can't be an answer for PwC when they did not insist on a joint trial.
No, indeed, and it's a different point. If this is a Henderson time point, should we have raised it? I have to deal with that rather more in a few minutes. But the judge's decision that we shouldn't have permission to amend, basically because there might have to be disclosure and that was all too late, is not a decision that, on the question of whether we could and should have raised it. It's simply a decision as to whether it was fair as between ourselves and the defendants to let us do it when we did. It wasn't saying, well, you could have done it sooner and you should have done it sooner. It's simply saying, well, you can't do it now. As a matter of fairness between ourselves and the other defendants, nothing obviously to do with PwC.
Thank you.
Laura, I'm grateful. Now, I don't think I need to I mean, the model errors, I don't know whether I need to explain those, but they do operate entirely independently. One of them concerned OU1, but it's not actually the same point as OU1. They're pure mathematical errors. Just very briefly, I mean, the NRD liability that was attributed to API NCR in the 2008 accounts of 11.3 million was simply in the model, in the mathematical calculation, included in the wrong place. So it was treated as if it were an NCR API liability. Whereas in fact it was an API liability. So if it was NCR API was going to be liable for 60% of it and NCR 40% of it. So because it was mistakenly treated as if it was an NCR API liability, it was reduced by 40% when it shouldn't have been. So a simple $4.5 million mathematical mistake. That's the first error. The second one was this OU1 $10 million credit. Now that was included as if it were an API credit. And obviously if it's an API credit, it can be included in full, the full 10 million. But actually it wasn't, it was NCR and API who had spent the 10 million. So it reduced to 40%. So there's a 4 million error there. So these are simple mathematical errors. And quite obviously things that the auditors ought to have spotted. And they would have resulted in there having been a provision. And when one thinks about the causation point, just for a second, if they had to include a provision of, say, $6 million, they couldn't have eradicated the intercompany debt with the payment of a dividend. They'd had to either find another way of doing that, or give up on the idea of Sequana selling the company to Mr. Gower and Mr. Tauscher. So even a small change like that would well have resulted in no dividend being paid in 2009 at all.
And that's because they were so close to the 150 million it was under the Maris policy.
Yes.
The idea was always to, as I understand it, that the figure they arrived at was the figure was below the limit of the Maris policy. So it left a small amount of headroom. And you're saying that even with 4 million or 8 million mathematical errors, that would have meant that the figure should have been not 146 million, I think that was the figure, but 154 million. Is that?
Yes, because you're absolutely right, my lord. The way they calculated the provision was to work out what the figure should be and then take off the Maris figure.
Yeah.
Now, they got those two figures to parity and therefore decided there shouldn't be a provision and therefore were able to pay the big dividend in May 2009. But in doing that, they left the company with, I think, about $3 million net assets at the end of it all. So they had they were right down to the bone. They needed to pay pay a big enough dividend to wipe out the intercompany debt, which they did in fact. But if they had had to include a provision of really anything more than about 3 million, they couldn't have done that, because that would have put the company into insolvency. Obviously couldn't pay the dividend. So they were right down to the wire here.
I suppose they could have paid a lower dividend, or would that not?
Well, they could have paid. They could lawfully have paid a lower dividend, and PwC might, in due course, say, well, that's what they've done. But my point here is that they wouldn't necessarily have done that at all, because, as the evidence before Mrs. Justice Rose made very clear, what they wanted to do at that point was to get rid of the intercompany debt, so they could sell, Sequana could sell the company to Mr. Gower and Mr. Tauscher.
Well, this doesn't sit very easily with your acceptance, not very long ago, of the bona fides and general lawful instincts of
Well,
these
no,
directors.
that's entirely consistent with Mrs. Justice Rose's finding. She said, well, they acted conscientiously, and there's nothing wrong with having a target, a purpose you're trying to achieve, as long as you're not trying to achieve it come what may, regardless of your duties. That's exactly what she found. Now, and that's exactly what we say. So they got to the point where, this is what Mrs. Justice Rose found, they could conscientiously say, yes, we think this is the right provision, yes, we will pay this dividend. And we have, to be clear, trial one, we were saying that they were of a very different mindset, but that's not what Mrs. Justice Rose found, and it's not what their evidence was. So she found they were behaving conscientiously. So the fact that they had a purpose, a target they were trying to hit, is not in itself improper. It was simply the question was, were they doing it regardless of their duties, or were they only going to hit the target if they could do so consistently with their duties? And she found the latter.
Am I right to say that at least one of those errors was referred to in the judgment?
The modelling errors.
Yes.
Yes, because we
191, paragraph 289 says there were mathematical errors and identifies the figure being wrongly treated as NCR-API.
Yes, well, that's right. Because they came to light really during the trial when we were working out how the model actually worked.
But was the judge invited to draw any conclusions from that? I mean, it's noted, but that appears to be it.
But the problem was we hadn't pleaded a claim on that basis. We'd only come across it as we were working out the maths with the, I think probably with the accounting experts.
So you say the fact that it's referred to there, to that extent, it's correct, and that effectively is the end of that point. It's simply referred to in the judgment.
Yes.
That you're not seeking, because you couldn't in that case, you say this isn't an attack, it's effectively taking a point that was referred to by the judge and, in that sense, making a case on it.
Yes, she made factual findings about it, but you'll notice that in her judgment she didn't say anything about what the consequence of that was, because we weren't able to say therefore the provision was wrong, so she didn't address that. Now, as regards to going, the final one of the new points I need to say something about just very quickly, the going concern point, just to be clear, there are two ways in which we put this. The first is to say that the going concern assumption was not appropriate, and that I accept ties in with our attack on the provision, because we say to the extent the provision was wrong by even a very small margin, as I've just indicated, the going concern assumption was therefore clearly inappropriate. Because if the provision was, they put in the provision that they did, and in fact it should have been 5 million higher, then, and they paid away all the assets, leaving only 3 million net assets, then clearly there was a going concern problem. It was insolvent. So that's the first way we put it. Now, PwC tend to focus on that very closely, but there's also the second way in which we put it, which is rather important, because we also say that even if the going concern assumption was appropriate, there was at least material uncertainty as to whether it would continue to be appropriate. And ISA 570 expressly sets out what has to be done in that situation, which is to provide disclosure of that fact in the notes to the accounts, and for the auditors to include an emphasis of matter drawing attention to that. So they can't basically give a clean audit opinion if there's that material uncertainty. And that, at the very least, was required. Now, PwC want to say, oh, well, that's of no real consequence. The directors would have ignored that. They knew everything. Well, we say, no, it's a weighty matter indeed. The auditors are forced to include an emphasis of matter that calls into question the going concern assumption in that way. It's not the same as the emphasis of matter that they actually included, because they actually included an emphasis of matter, drawing attention to the fact that there were very significant matters of judgment involved in the provision figure. That's one thing, but it's quite another to say, actually, there's a material uncertainty as to going concern. So the consequences of the issues being wider are really these, my lord, if I can pull things together. First, we don't have to succeed on any of the issues where we admit there is an overlap in order to win. We can actually win without doing that.
Sorry, just say that again. Don't
Well,
succeed.
we accept there are areas of overlap, and we accept that we're inviting to some extent a decision which is inconsistent with elements of Mrs. Justice Rose's reasoning. But we don't have to win on that. We can win on points where there is no collateral attack. The second consequence is that inevitably the evidence is going to be wider. Documentary, witness evidence, expert evidence, because there are many new points. We say the evidence will be wider even on the areas of overlap. That's a separate point I'll come to later. And I've explained, I don't need to explain again, that even within the areas of overlap, we do not attack the credibility of the director's evidence given to the court in the first proceedings. In fact, in many respects, we rely on it. Lords, I said I'd deal with Kalamazoo separately. I'll just do so quickly, if I may, and move off this question of overlap. The Kalamazoo non-disclosure question is a different one to the Fox, as I've said, because Kalamazoo was an entirely separate potential liability. At that point, potential. At this point, of course, as hindsight shows, very actual, because NCI has been found liable in relation to the Kalamazoo pollution for many millions of dollars. But at that point, the question was, as at the dates of the two accounts, should there have been a disclosure of a contingent liability? Was that remote? Now, Mrs. Justice Rose held that the lack of disclosure, clearly there wasn't any at all, the lack of disclosure was not relevant to the Part 23 question, the question of the lawfulness of the dividends. But she did, it's fair to say, go on to say what she would have found, strictly speaking entirely obiter and unnecessary to her decision, or what she would have found as regards the remoteness question. Now, we do say that as a consequence it can't be an abuse, or it's certainly less likely to be an abuse if this is wasn't part of her decision, but a finding that she made on an obiter basis. We also will actually be inviting, again, the court to come to a different view on this without challenging the factual evidence that was before her. Because what Mrs. Justice Rose essentially did there, in particular one can see this from paragraph 642 of her judgment, just from my Lord's note, is that she found that on the basis of the material that the directors had, there wasn't any reason for them to consider that this was remote. Now, with respect to the judge, that wasn't perhaps the question, or at least while it may have been before her, it certainly isn't the question in these proceedings. The question is whether objectively this liability was remote or not, by reference to not just material the directors actually had, but material that was reasonably available. And we will say, that actually, if one looks at the material that was certainly available to the advisors, which doesn't seem to have filtered through to the directors for some reason, it was very clearly more than remote. But I'll come on to that if I have to in more detail later. But that's just to explain the nature of the point. So, my lords, I apologise for that rather large digression, but it's very important, I would submit, to understand exactly what the extent of the overlap, the limited extent of the overlap between the two sets of proceedings is. Now, having done that, one can then look at the application of the principles as regards when there is an abusive collateral attack and apply them to the case. And in particular, we do invite attention to the Wilson decision, which my lords have seen. If I can just explain what we say about that. I think it's still common ground that the principles are set out in the judgment in Wilson. And a comparison with Wilson is also illuminating. One does need to be careful, as we've all accepted, in relation to analogizing. But Wilson is instructive. In Wilson, as my lords know, the first instance decision was that it was an abuse. It was put the central allegations were entirely inconsistent and contrary to the findings in the first proceedings. But the Court of Appeal allowed the appeal because the high threshold for abuse, as it was put, wasn't met. And there were a number of, this is paragraph 88 and following of the judgment, there are a number of material considerations which weighed heavily against the conclusion that it was an abuse. We look at these now just quickly because we say each of those applies here as well. So the first was in Wilson.
Hang on a moment, we need to get the case out now.
Certainly, it's paragraph 88. It's in tab 17 of Appeal Authorities Bible 2.
So the principles of paragraph 48 that you say we have to bear in mind.
Absolutely.
And then you were taking us to
88.
88. Which is what, as I've indicated, what's at 87, it said, but despite the arguments and the judge's careful reasoning, this court's concluded that the high threshold to engage the court's duty to act to prevent abuse has not been met. There are a number of material considerations which weighed heavily against the conclusion that the claim was an abusive process. And my submission is that actually each of those really applies here too. And the first one in 89 was that, of course, the defendant in that case hadn't been a party to the arbitration. Also true here, of course. In Wilson, as we've seen, the defendant actually had a much greater role in the arbitration as a witness, as a funder of the defence of the claim in the arbitration, and he was interested in the shares. But here, of course, PwC's had no involvement at all. Second, still in paragraph 89, in Wilson, the defendant had been invited to join the arbitration proceedings and had refused. Same here. My learned friend says, well, PwC's opposition wasn't quite as entrenched, but nevertheless it may have been put on a rather more subtle basis, but nevertheless they declined the opportunity. So that's really the case management point. Then there was a lack.
They could have said, couldn't they? If they hadn't been wedded to their strikeout, they could have said, well, if there's ever going to be a case against us, it has to be tried at the same time as the.
Yep. And they could have said, and if there's a second trial against us, we'll be saying abusive collateral attack. So actually, there really has to be. Well, it certainly prompted us to say there really has to be there for a single trial. So they certainly had a way of avoiding this, or alternatively of making, well, it would have come to the same thing. They could have made their position a lot clearer, in which case we wouldn't have ended up here. Mr. Justice Mann would have inevitably said, well, there's got to be a single trial there. And we certainly wouldn't have agreed to drop that application for a single trial if we thought we'd end up in the position we're facing on PwC's submissions at the moment. But in terms of...
Nobody seems to have thought of it, they do. I mean, it's odd. If the case management conference had proceeded one can't help thinking that at some stage, either the judge would have raised it or somebody would have said, well, hang on a minute, what's going to happen if case goes on against the directors and you lose? Are you, presumably at that stage, you're going to abandon your claim against PwC, at which point you'd have said, well, no.
No, no, no.
No, no, no.
Absolutely. We don't know, but that's a perfectly plausible hypothetical, yes.
Yeah. Okay.
But the point is, for comparison with Wilson, it's the same. Invited to join, refused. There's the lack of mutuality point, paragraph 90, again, same here. And PwC's position is that, except, of course, it's not bound by the findings in the first set of proceedings. Malone Friend tries to say, well, we, BTI, would have had, I think as he would have a very big leg up if, in fact, we had won in the first set of proceedings, trying to suggest that, or maybe PwC might have had to accept. I think we could bet our bottom dollar on this side of the court that PwC would have instructed Malone Friend in the event that we'd won against Sequana that PwC's submission was, we are not bound by this, and you, BTI, will have to go and prove it all over again against us. Absolutely clearly. There's then the question of whether there's no question in Wilson of the defendant being vexed twice, because he wasn't party to the first proceedings as here, and that's paragraph 93, and also paragraph 93 in Wilson, the claimant's only means of making the claims was, of course, through the second proceedings, as here. And
Which paragraph is that?
still 93, my lord. Going over the page.
Right.
So no question of being vexed twice, no other way in which the claimant could make the claims. And in 94...
Yeah, I'd forgotten that Mr. Emmett had been joined to the proceedings at some point. Joined to the court proceedings at some point by the defendant.
Oh, well, yes.
And then
and mysteriously disappeared. I think the...
And then
and he was mysteriously dropped.
Yeah, any judge who ever sat in the commercial court will be familiar with Michael Wilson and Partners and Emmett, and in all its glory over many years, Mr. Thompson.
Yes, and I think the Court of Appeal in this particular decision smelt a rat and realised that joined a...
Well, Mr. Justice Tier clearly thought something
yes.
funny was going on, yeah.
So, and the Court of Appeal in 94 decided that the first instance judge put too much weight on the fact that the claimant was inviting a different conclusion to the arbitration proceedings. And that's here, really, PwC's only contention. That there is an invitation to inconsistent decision. And finally, the first instance judge in Sinclair appeared to reverse the burden of proof. Now, great emphasis was placed, as we've seen in Wilson, on the lack of mutuality point. And we do say that here PwC's position is particularly unattractive and essentially opportunistically trying to effectively leave BTI bound by the findings in the first set of proceedings, indirectly via collateral attack argument, whereas it itself is not bound by them and was never going to be bound by any adverse findings made in the first proceedings at all. Now, one of the points that my own friends come up with is this idea that, well, in the first proceedings, the issues were determined between, as he puts it, the most appropriate parties. I'll deal with that here quickly, because in our submission, that's a novel principle. It's not of any real relevance, and it's entirely inconsistent with the Wilson decision. For a start, it's no part of the principles identified in Wilson, paragraph 48. But also, it clearly wasn't applied in Wilson, because clearly the most appropriate parties to decide whether there was bribery of a fiduciary were, of course, the fiduciary and the principal, so the parties to the arbitration. And yet, that was not regarded as in any way an obstacle to the litigation in which exactly the same bribery question was going to be determined, but as between the alleged knowing assister of the bribed fiduciary and the principal. So if it's a really significant consideration as to whether in the first proceedings the appropriate parties, as Malone and Friend puts it, have been party to the decision, then that's completely inconsistent with Wilson. It's also actually inconsistent with the example in the Braganosianus case. Got a telling example in Lord Justice Carr's judgment. Again, this is 138, column 1. He just gives the scenario of, hypothetically, a negligent accountant reporting on the company's affairs for a client who's a potential buyer. And he imagines that the client sues for the fees, the accountant sues for the fees, and the client defends with a negligence allegation. And that's successful. So there's a finding that the accountant was negligent. But there's no question there, said Lord Justice Carr, of the accountant being unable to defend a negligence claim later by a third party. So again, if it were an important consideration to look at whether the appropriate parties were the ones party to the first proceedings, then that example would have been put very differently. Clearly, the most appropriate parties to determine a negligence allegation are the advisor and the client.
I think that Mr. Salzi's point was the point that really my Lord's been putting to you this morning, namely that in a counterfactual, evidence from the directors is likely to matter, and therefore that's why the directors might be regarded as being important, whether who's more important than the other I'm not getting into, but I think that is really the underlying point, certainly as I've understood it.
Thank you, Lord Anderson. Well, that may well be, my Lord may well be right. I think there's a more fundamental point being angled for, at least, that it's not just a question of whose evidence is required, because that doesn't necessarily follow from who the parties are. I think he's saying also that there's simply a point of principle as to who the appropriate parties are. And I would say that also the premise of the argument is false, because you can't say that the directors are more appropriate parties to have this point resolved than the auditors.
No.
In both claims, the company's basically saying the accounts were wrong, and in the first claim, we were saying, well, that's the director's responsibility, as indeed it is. And in this claim, we're saying that that's the auditor's responsibility, as indeed it is, and there's no inconsistency between the two. They've just got different roles in relation to the accounts.
I mean, to state the obvious, at the most basic level, the auditors must be a necessary party to any proceedings alleging that their negligent conduct of the auditors caused loss to your clients.
Yes, indeed. Indeed. So there's nothing in that point. Now, moving on now then to the case of Lang, which Malone and Friend puts great weight on. He doesn't suggest that Lang is authority for any different principles to the Michael Wilson principles. Now, effectively, therefore, he's arguing that this case is analogous to Lang. Now, even if analogies are useful, we're aware how careful one needs to be with those, there isn't really an analogy here. In Lang, the collateral attack was on a relatively simple, well-defined, entirely factual issue. Basically, what was agreed between the two protagonists. And it basically turned on the credibility of the two relevant witnesses of fact. And one sees, I don't know whether my lords saw it, but in the judgment of Lord Justice Moses at paragraph 37 of my lord's note, he puts his finger on it because the problem was that the judge in the second set of proceedings was going to be invited to take a completely different view on the credibility of the witnesses to the judge in the first set of proceedings on this narrow factual point. And also, critically, it's found the evidence was going to be exactly the same. There, of course, also, the second set of proceedings were issued only after the first had been determined, so there's no case management question at all. And there was no attempt to join the defendant in the second proceedings to the first. So for those reasons, Lang was a rare exceptional case where it was an abuse, despite the lack of mutuality, but only because of those factors, which are not present in the present case.
Well, the absence of any attempt to join, it must be, on any view, a powerful factor.
Oh, yes. Well, oh, yes. But if one looks at Wilson, Wilson's clearly on the other side of the line.
Well, Wilson is a case where they couldn't join because it was arbitration.
Well, they couldn't insist on joining.
They couldn't insist
but they
on
invited
joining.
him
They
to
couldn't
join.
insist. They invited him to participate, and he refused to do so.
He refused to do so, exactly.
And that's and then gave evidence for Mr. Emerson, funded his defence from
Yes.
recollection.
Indeed.
So you can see why Michael Wilson and Partners was decided in the way in which it was.
Indeed. But equally, one can see the reason why Lang was decided in the way that it was. And, but basically, we say that this case is distinguishable from Lang on rather stronger grounds than Wilson, partly because of the case management aspect, but also more generally. And it is important to note that the issue, which was said to involve a collateral attack, the issue of overlap in Lang was very different to the issue in this case. A narrow, factual issue, rather than a complicated question involving fact, US law, and accounting expert evidence. And I emphasise that we are not coming along to challenge the credibility of the witnesses who gave evidence before Mrs. Justice Rose, in very clear distinction to the position in Lang. Now, the other case that Malone and Friends rely on is the Art and Antiques case, my lords. Probably deal with that rather more quickly because they don't really give any explanation of their skeleton. It's Appellant's skeleton in paragraph 49, which probably reflects its real importance or lack of it. In that case, of course, the abusive collateral attack that was found to exist related to the claim against the broker. But the important points here were that it was acknowledged that the abuse argument was weaker, of course, because the broker had not already had to litigate the matter. That's paragraph 44. Most importantly, there was no new evidence the judge held that would cast doubt on the arbitrator's decision. And it doesn't appear to have been suggested that there even might be any evidence. That's paragraph 46. On the contrary, the further evidence, such as it was, appeared to confirm the correctness of the decision. That's paragraph 46 again. And there had been an appeal against the arbitrator's decision which had been dismissed on the grounds that it wasn't open to serious doubt. So therefore, the court held that in all the circumstances, administration of justice was brought into disrepute, and, importantly, that it would be oppressive and unfair on the broker. So none of those factors are present in this case. And Lords, that really sets out, to a large extent, the positive case that I indicated I was going to advance. What I need to do really now in relation to ground one is to deal, I hope fairly briefly, with a number of the criticisms that are made by the appellant of the judge's reasoning. Because we do ultimately support the judge's reasoning as well as adding our own positive case. Now on the law, PwC effectively make three criticisms. These are perhaps important because if the court is going to follow the stricture, requiring it to give considerable weight to the decision of the first instance judge, then unless PwC can point to something that he got wrong as a matter of law, there is real force in following the reasoning of the judge. Now, 3 points are taken in this respect by PwC. First, they argue that Wilson was about arbitration only. Well, in our submission, very clearly not. The general statement of principle, particularly in paragraph 48, are very clearly not put in terms of arbitration at all, but are entirely general. Now, the learned friend pursued an argument yesterday as to whether the reference to the lack of mutuality being highly material, if not dispositive, meant purely that it was highly material and the if not dispositive doesn't add anything. I don't really think one's going to gain a great deal of assistance by arguing back and forward over that. The fact is, lack of mutuality is at least a highly material factor. Whether it's close to dispositive or not, this case is not going to turn on that in my respectful submission. But the natural meaning of that is that it is a highly material and, in many cases, dispositive factor. And the second criticism made is that the learned judge is criticised for supposedly holding that it could only be an abusive collateral attack if the second proceedings are based on the same evidence and raise the very same issues. He didn't say that. All he said at 82 of the judgment is that that was a highly material consideration. Of course, they are highly material considerations. You don't have to show that the evidence and the issues are exactly the same in order to demonstrate an abusive collateral attack, but if you can, it's certainly relevant. See Lang. If you can't, equally, it's highly relevant. Then the third criticism made, and this is paragraph 26 of the appellant skeleton, is that if BTI's claim is, as they put it, otherwise a collateral attack, it's not quite clear what that means, then the burden at the summary stage, they say, falls on BTI to show that the second set of proceedings is based on new evidence. So that's the burden. But they go on to say that that new evidence has to be such as to entirely change the aspect of the case. There's a reference there to phosphate sewage. So we'll also read 2 points here. There's who bears the burden and what is it. So breaking that down, as regards the question of who bears the burden, well, it's hardly a relevant point in criticising the judge, because this wasn't a case where the judge didn't make findings of fact on whether the evidence was going to be different or not. He clearly did, so he didn't decide the question on the basis of burden at all. So one questions its relevance, but as regards the burden, clearly the burden lies on the applicant, and that's set out in the Wilson decision at paragraph 100. I'm not sure that's really disputed. It's obviously consistent with general principle. It's consistent with general principle actually specifically as to factual matters in relation to summary judgment and strikeout applications. We included in our skeleton at paragraph 10 the authority E and Dorset County Council decision of this court, where Sir Thomas Bingham made the point, which is uncontroversial, that's why the authority is not in the bundle, that it's for the applicant to strike out to establish that the matter is not sensitive to the facts. It's also common ground that what the court's got to do on a strikeout application is take account of evidence that is reasonably expected to be available at trial. So it'd be inconsistent with all of that to come along and say, right, when it comes to this particular question here, the burden suddenly falls on the claimant to identify exactly what the new evidence is going to be and how it's going to be different to the first set of proceedings. So it's wrong in principle. It's also wrong in principle because, as a matter of practicality, it's entirely unfair. rather extraordinary consequence to say, well, okay, you claim that you can't identify enough new evidence at this stage before you've even seen a defence, let alone...
Well, I was about to say, in circumstances where you haven't had a defence, let alone disclosure,
Exactly.
it's a bit difficult to see how this point really runs.
Exactly. So, my Lord, that's the point I was about to make. So, I'm grateful, and I'll close there. Now, the other point, apart from the burden, is what the test is. And my own friend relied on the phosphate sewage case, although it's not actually in the bundle, because it's referred to in Lang. This may not be what PwC is saying, but in their skeleton argument, paragraph 26, they appear to be saying that, well, it's an abusive collateral attack to invite an inconsistent decision unless the claimant in the second proceedings can show that there'll be new evidence which, to quote, is such as entirely changes the aspect of the case. Now, that's taken from the passage in phosphate sewage cited in Lang at paragraph 25. Now, that's wrong in principle first, because clearly there isn't any such rule. The question is actually whether in all the circumstances it's an abuse to invite an inconsistent decision, either because it's manifestly unfair on the defendant or because it brings the administration of justice into disrepute. That's the test. There isn't any gloss on that says you've got to point to evidence that entirely changes the aspect of the case. And so, if that is the submission being made, it's entirely inconsistent with all the statements of principle in the leading cases up to the House of Lords that we've referred to in the section on law, which is largely common ground, at least, as all set out in Michael Wilson.
Was
No
phosphate sewage cited in Michael Wilson? I can't remember now.
I don't think it was. Let me check. Does not appear to have been.
No.
But the various general principles identified in Michael Wilson derive from, amongst others, Norris and Hall and Simons and Bragg and Asianus, would all be wrong if such a general principle existed. So, for example, if it's correct, as it clearly is, that it's a rare case where there's an abuse, if there's no mutuality, then, well, that can't be, that would be entirely inconsistent with this supposed phosphate sewage rule. Because if you had to show that there'll be evidence that entirely changes the aspect of the case, it wouldn't be rare at all. And
we don't have phosphate sewage.
no, we don't. We don't rely on it. And,
Well, I understand that. I mean, I think you might be groping towards suggesting it may be wrong.
oh no, I'm not. No, let me explain. No, let me, because the point about phosphate sewage is that it's a res judicata case.
Yes, well, that's...
So I don't say it's wrong at all.
Sorry.
Sorry, the point about phosphate sewage is what?
It's a res judicata case.
Well, I was going to say, I mean, I think
It's got nothing to do with
I think I dealt with phosphate sewage in Komoka.
Yes, I think you might have done that, yes.
But isn't, yeah, I was about to say it's a res judicata case.
It's a res judicata
Because it's
case.
the same parties.
Yes, exactly.
Yeah, right.
All it's doing, phosphate sewage in itself, is completely irrelevant to this.
Yeah.
It's the point that if you've got a claim that you could have brought in, if you've got a new claim that you don't bring in the first proceedings, that you then commence separate proceedings, if you want to run that claim and not fall foul of issue estoppel and res judicata, you've got to demonstrate that the evidence you're going to put forward second time round, you couldn't have put forward first time round, and it is such as entirely changes the complexion.
Lord, exactly. That's precisely my submission. I'm grateful.
Anyway,
That's
I think
that's what it decides. And the reason that my learned friend PwC have seized on it is because it's referred to
Paragraph 25 of
Lang.
Lang.
Part of the argument. Now, what just very quickly, what the reason why it's referred to by Lord Justice Buxton there is because he's not importing that principle into this jurisdiction, into this type of abuse. because if one goes to paragraph 25, this is at page 311, he says, I therefore conclude that it would bring the administration of justice into disrepute if Mr. Lang were to be permitted in the second claim to advance exactly the same case that was tried and rejected by His Honour Judge Thornton. If Judge Thornton's judgment was to be disturbed, the proper course was to appeal rather than to seek to have it in effect reversed by a court not of superior but of concurrent jurisdiction hearing the second claim. That the second claim is in substance an attempt to reverse Judge Thornton is important in the context of wider principles of finality of judgment. So what he's doing is he's saying, well, let's just stand back and look at the wider position here. And he's saying, he refers to Hunter, and then he says, where wholly exceptionally a collateral first instance action can be brought, it has to be based on new evidence that must be such as to entirely change the aspect of the case. See phosphate sewage. So he's saying, well, let's look at what the position would be if, in fact, what they tried to do was bring a first instance action to challenge His Honour Judge Thornton's decision. Well, they'd have to satisfy the phosphate sewage test. So if that's an action with the same parties, so it's phosphate sewage, as I say, is a res judicata decision. And he then goes on to say the second claim in our case not merely falls short of that standard, but relies on no new evidence at all. So one can see the ratio of the decision, which is that there is no new evidence at all. It's running, as it said in the first sentence of paragraph 25, exactly the same case. And all he's doing by referring to phosphate sewage in my submission is just drawing an analogy with the position that would exist under the res judicata rules if, in fact, instead an attack on the Judge Thornton decision were being made as between the parties to the original claim.
Far be it for me to suggest that Lord Justice Buxton didn't quite express himself as, with hindsight, he might have wished.
My Lord's in a better position to make that suggestion
Yeah,
than
I
I am.
I mean, it's a very odd passage, isn't it? Because it begins by saying, where wholly exceptionally a collateral first instance action can be brought. If you just pause there, what you're talking about is a second claim against a different party, then all the other authorities really point the other way.
Yeah.
Far from it being a rare instance that you can bring the claim, it's a rare instance that is an abuse to bring the claim.
Yes.
Or wholly exceptional, or whatever the phraseology is.
Absolutely.
So, as my Lord says, one slightly wonders what the thinking was there.
I think what the learned Lord Justice is referring to there is the possibility of an attack as between the same parties to the original proceedings.
But if so, what's the relevance of that? I mean, it's...
He wasn't dealing with
He
that.
wasn't dealing
Well,
with
no,
that.
he wasn't.
And everybody has agreed that completely different
Yes.
rules and principles apply in those circumstances.
Absolutely.
And that's not this case.
But I think my respectful submission, for what it's worth, is that the clue is in the sentence above, when he says it's important in the context of wider principles of finality of judgment. So he's looking more widely and saying, well, what would the position be if actually...
But at all events, you say phosphate sewage ultimately is irrelevant because it's a res judicata case.
Oh, yes. And that's
Probably fair to say this was an unreserved, looks as though it was an unreserved judgment too, so perhaps may not have been phrased as quite the care we might have expected in a reserved judgment on that tiny point.
quite possibly, yes.
Yeah, difficult to tell, isn't it?
It is difficult to tell, I agree with you.
Now, then...
Oh, no, sorry, that can't be right, because Lord Justice Law says I agree with both judgments before Lord Justice Moses has given his. So,
Yes.
so sorry, I withdraw
Unless he
that
had a
suggestion.
crystal ball, it's not.
Yeah.
Unusually prescient.
But in any event, as a matter of principle, it simply can't be right. As my Lord Justice Coulson says, phosphate sewage is clearly irrelevant. Now, those are the criticisms, the legal approach to the law taken by the learned judge that PwC makes. Then PwC makes a number of criticisms in relation to his application of that law to the facts. Again, I'll try and deal with these as quickly as I can. The first criticism, there are really four remain. This is in the skeleton, the Appellant 27, paragraph 27 to paragraph 47. The first one is that the judge is criticised for his analysis of BTI's claim against PwC. I don't really need to add anything much more here because I think I've explained the nature of the issues arising here. And essentially, PwC is trying to say that the issue of whether the relevant accounts were true and fair was one, decided by Mrs. Justice Rose, two, arises in exactly the same form in the second proceedings, three, has to be decided in our favour in order for us to win at all, and four, has to be decided for that purpose inconsistently, with the decision of Mrs. Justice Rose. For the reasons I've explained, I'm not going to go through again, all of those 4 points are wrong. Now, another related point that's been taken, I think, first in the Appellant supplemental skeleton, related to this, is a point about the scope of the auditor's duty. Because it's said there that the auditor's duty is very narrow. It's really just to express a particular opinion.
Well, I think the issue that Mr. Salzedo focused on is at various points in the judgment, the judge does appear to be contemplating that PwC were giving advice.
Well,
I think that was the point.
That's certainly a point that he made. Now, in relation to that, I would accept that it might be better to phrase that a little more carefully. But what the judge was getting at in that submission, respectfully made, is that the reality is, as I've already submitted, the auditor's job and the preparation of the accounts involve iterative processes. That is the fact. One sees that actually from the facts of this particular case. Mrs. Justice Rose deals with the auditor's involvement in the run-up to the May 2009 audit. There's a point my learned friend actually relied on, wanting to make the point that actually the audit wasn't done just overnight on a Sunday or a Monday morning. Stretched back a bit further. And the particular point that Mrs. Justice Rose identified was, at one stage, what the company was trying to persuade PwC of was that it was okay to put in a contingent asset for the claims against the insurers. PwC, with respect, quite rightly said, no, you can't do that. We'll have to qualify if you do. And so they gave up on it. So that's entirely typical of the to and fro that's necessarily involved. And it's strictly correct that they may not be giving advice, but what they are doing is indicating that if that approach is taken in the accounts by the directors, whose accounts, who are responsible for the accounts, then the auditor won't be able to give an unqualified opinion. They have to qualify. And we all know that what that will necessarily involve is, unless the directors are prepared to put up with a qualified opinion, some change in approach in the accounts. They can't persuade the auditors to shift their view. Now, the specific point that's taken in the supplemental skeleton I'll deal with very quickly. It's suggested that all they've got to do is express an opinion as to whether the accounts are true and fair. Well, I've shown, my lords, section 235 of the Companies Act 1985, which is wider than that in terms. It's that the accounts are properly prepared, including that they show a true and fair view. And we don't need to turn them up, but we can see from the actual opinions expressed by PwC on the relevant accounts in this case, that's exactly what they did. They don't just express a view about true and fair, they express the view that the accounts are properly prepared. Just for my lord's notes, 2007 accounts, that's volume 2, tab 13, page 268 to 9. And for the 2008 accounts, it's volume 2, tab 18, page 319 to 320. So, for example, if there was a lack of independent legal advice, then at the very least, regardless of whether they thought the lack of that rendered the accounts not true and fair, at the very least, it would render the accounts not properly prepared, and so they couldn't give properly the opinion that they had to give. Now, it's also the case that, in any event, that's all about the position as a matter of tort. In fact, we do plead the engagement letters, just from my Lord's note, that's amended particulars of claim, paragraph 206, which is page 197 in the first bundle. And we plead that they took on a contractual duty to conduct the audit in accordance with international standards. So that goes beyond merely expressing the opinion. Also a contractual obligation as to how they're going to carry out their audit. I'm not sure anything turns on it, but it shows that the point being taken by PwC at this stage is ill-founded. Now, then, the next criticism as regards the judge's application of the law to the facts is that it's said that the judge relied, or he's criticised for his reliance on the new points. Basically, there are 2 points being taken here, it seems. There's an argument that the new points are hopeless, which seems to have transgressed into ground 1 of the appeal when one would have thought it might have been really a ground 2 point, but it's seeped in. And there's also an argument, it seems, that the new points should have been raised in the first proceedings. So I'll have to deal with these, I suppose, point by point as swiftly as I can. Now here, the new points that are actually referred to in the appellant's skeleton arguments are the OU1 point, the modelling errors, and the going concern point. So I'll just deal with the points that are actually attacked by PwC, despite the fact that actually that doesn't encompass all the new points, because my lords will have noted it doesn't deal with the 100% point. And nor, of course, does it deal with points which, while they're not entirely new, represent things where there is no overlap with Mrs. Justice Rose's findings, on which I've addressed my lords earlier. So let's deal first, as quickly as I may, with the argument that these new points are hopeless. In relation to OU1, really, there's no analysis in support of this argument, just a jibe that we are said to be scraping the bottom of the barrel, because it wasn't considered a point worth pursuing in the first proceedings. Well, quite obviously it was a point we tried to pursue in the first proceedings, as I explained, but we weren't permitted to. And it's obviously a perfectly credible point, because at the very least, if the arguments made...
But it ties in with the legal advice point.
It does. Well, it does, in the sense, if it's...
You know, at least arguably, that independent legal advice would have included something along the lines of, well, you can't really read across Burlington, or you can't necessarily read across Burlington Northern as excluding any arranger liability in respect of upstream activities.
Absolutely, my lord. If it's right that the treatment of OU1 in the 2008 accounts was purely based on the view being taken of Burlington Northern, if that's right, then it follows that if we're right about how they should have dealt with Burlington Northern, in particular under FRS 12, then at the very least they should not have been writing out the 60 million liability in full. They should have been writing out only part of it at most. And they shouldn't have been including all of the 10 million credit that they brought in, but only part of it, because they would have to allow for the possibility that the basis on which those two things were being done was actually not correct as a matter of law. So that's clearly not hopeless. Now the model errors, well, you cannot say those are hopeless points. They're pure mathematical errors, and one was a matter of finding a fact by the judge, the other is fairly clear, and really, as regards an auditor's negligence claim, it's often being hopeless, it's pretty slam dunk, because the one thing you hope the auditors might do is check the maths. And this is a purely mathematical point applying the model.
So arguments about margins of error wouldn't really apply, would they?
Well, not really. This is
Because it's not like where you're assessing a provision and there is a margin of error there because it's an exercise of judgment.
Yes.
If the auditor identifies a mathematical error, where they've simply added up a column of figures incorrectly, for example, then there can't be any scope for saying, well, there's got some discretion in the directors there. They just got the maths wrong.
Exactly. They got the model was designed to apply a particular approach, basically just apportioning the NCR API liability 60/40 according to a settlement and an arbitration that had followed. So the principle is absolutely clear. It's just the maths was wrong. So absolutely, my lord, it's not a judgment question at all. I mean, in relation to going concern, the third of the 3 points said to be hopeless. Well, I hope I've explained enough about how that argument works to show that it's clearly not hopeless. If, as regards the first element of it, it goes with the provision point. So if the provision is wrong, clearly the going concern assumption is wrong. That's the first way we put it. As regards the second point, that is that there needed to be disclosure at the very least and an emphasis of matter in relation to a material uncertainty as to whether the going concern assumption would remain appropriate. Well, that is clearly at the very least a claim with a reasonable prospect, because as I've explained, if in fact the provision turned out not to be wrong in the sense that it was a badly arrived at provision, but in the sense that it didn't reflect the actual liability. So not wrong at the time, wrong with hindsight. It turned out to be wrong with hindsight to even a small degree because of the huge dividend they were paying on the back of these accounts. The going concern assumption would obviously have been undermined. So there was at the very least a material uncertainty as to going concern. And it's not the same point as to whether the creditor's interest duty was triggered or anything like that. It's material uncertainty that's the test. And we know that by December 2009, if they'd been asked in December 2009 after the trial in the Whiting litigation that found 100% liability, they'd have had to say, oh dear, the going concern assumption is probably not appropriate. At that point, the finding was 100% liability. So on the basis of the much lower provision that had formed the basis for the dividend that by that stage had been paid, the company would have been real problems. So that clearly can't be characterised as a hopeless point, quite the opposite. And I should say that what we say about the requirements as regards disclosures and emphasis of matter, they're all set out, derived directly from ISA 570. So this is based very clearly on accounting principle. The reference is in the particulars claim are paragraphs 192 to 193 and 256.
Sorry, two?
Sorry, apologies. 192 to 3 and 257.
257.
Now, then there is a sort of quasi-Henderson and Henderson point being taken. This is the argument that, okay, if these points aren't hopeless, they should have been raised in the first proceedings, and therefore they're abusive. Now, this is Appellant Skeleton paragraph 42. Now, the only form of abuse that's actually relied on is abusive collateral attack. So I think the argument seems to be that the abusive collateral attack that's alleged extends not just to attacking points that were actually resolved, but points that could and should have been resolved. That seems to be the argument. Well, our response to that is several layered. And the first point is that's certainly an entirely novel principle, not actually supported by any authority that's been cited. I mean, really, it's an attempt to bring in Henderson and Henderson type principles into the abusive collateral attack doctrine. And it would actually, quite obviously, radically extend it. No principled basis for doing that's actually been identified. And we would submit that's because actually it's wrong in principle. It's wrong in principle because the Henderson principle is obviously based squarely on fairness as between litigants. The underlying point, of course, is to prevent.
Where it's the same parties.
Exactly. Prevent parties being vexed twice. So it's directed at. Whereas on the other hand, the abusive collateral attack point is obviously directed at relitigation of things which have actually been decided. And that's particularly here, because here, this isn't based, this attack, this abuse allegation isn't based on any question of fairness or vexatious litigation. Instead, it's based on bringing the administration of justice, is alleged, into disrepute. It can't be said that it brings the administration of justice into disrepute because it's an abusive collateral attack. If what's happening is that fully arguable points are being raised for the first time in litigation between BTI and PwC. For that purpose, it just doesn't matter whether they could have been raised or should have been raised in the first litigation. They weren't. There's no way one can say that by raising them now, one is mounting a collateral attack on the decision in the first proceedings. It really is a rather desperate attempt by PwC on both these points, the no reasonable prospect point and the Henderson type point, to get around the fact that incontrovertibly there are wider issues regarding the compliance of the accounts in these proceedings than there were in the first proceedings. Now, also, strictly speaking, it's not really a point that's open to PwC because it never formed any part of their strikeout application or the evidence in support. It's not referred to in the grounds, it's not referred to in the two statements that were made in support by Mr. Hewitson, which are both in the bundle. Now, I'm not taking this point as just a formal point, but what it does mean is that the court simply isn't in a position anyway, even if it were in principle a sound point, to form any view as to the alleged premise, i.e. that the matter, each matter could and should have been raised in the first proceedings, because we haven't been asked to give any evidence about that. We've been challenged to explain why we didn't do so.
Well, OUI 1, you did try to raise.
We did.
And the judge held it was too late. So
Yes.
it's a bit difficult to see how this point would run.
It clearly doesn't.
What would be being said is, you should have thought of the point right at the beginning when you first pleaded your case against the other defendants.
Yes.
And that as a consequence of that, you're precluded from running this point against us.
Yes, and that only has to be stated to realise what
Well, that's
proposition it is.
about as broad an extension of Henderson as possible to imagine.
It is.
I mean, when it's between the same parties, that's a relevant consideration.
Oh yes, it is. It is. It is. So there's really nothing in that. Now then there's the subject of the 2007 accounts. Because the judge is criticised for placing too much weight, as it's put, on the fact that the 2007 accounts were not challenged in the first set of proceedings. Well, the short answer is really that it's matters of weight such as that pretty irrelevant to the outcome. mean, it's irrelevant to the outcome in any event because, as I've submitted, the case management point determines this in any event. And there are also numerous other reasons before we get to this as to why this is not a rare case where there's an abuse, despite the fact that the point hasn't been litigated between the parties. And questions of weight are obviously preeminently for the judge. So I think what they're really trying to say is, well, either there's no real prospect of success on this, and again, this is one of those points where questions of prospects of success seem to leak into ground 1 rather than remaining in their proper place in ground 2. Or they're saying, well, to the extent there might be, it's not really a new point at all. Now, necessarily, I'll have to deal with this fairly selectively, but can I just deal first with the non-disclosure aspect of all this? Because one of the criticisms we make of the 2007 accounts is that the necessary disclosures weren't included. And obviously, that's not something on which was an issue at all in the first proceedings. So there's no overlap. And I think what PwC is trying to say is, well, it's hopeless to think that would make any difference. They're really saying there's no real prospect of success on this. So can I just, if I can, very quickly, before the short adjournment, just explain why that's clearly not right. Court can't for a moment say there's no...
I think the thrust of Mr. Salcedo's case was really that the first dividend, the December dividend, was paid out in reliance on the interim accounts and not on the 2007.
Well, let me try and deal with that then. Because the non-disclosure point is a separate. That point relates more to...
I mean, you may be right that that's not really an abusive process point. It's really a strikeout point. But you've got to deal with it at some stage.
Yeah, if it's anything, that's what it is. Well, let me deal with that then as part of ground 2. Let's try and keep in their correct boxes.
Yeah, and the point was, on no view could the 2007 accounts have been relevant because of the size of the provisions in them. And also, there simply weren't any sufficient distributable profits looking at them to enable anything like as big a dividend as was declared in December.
Yes, let me explain my answer to that then, because the first point is that actually the question of reliance on a set of accounts when it comes to paying a dividend is rather more complicated than learned friends' submissions allow, because there are at least 2 questions that have to be answered by directors when they're deciding whether to pay a dividend. The first is what we dubbed the could not question in the first set of proceedings. So that's basically whether lawfully under Part 23 one can actually pay the dividend at all. And obviously if the answer is you can't, well that's the end of that. And for that purpose, yes, the 2007 accounts were relevant in the sense that you had to look at them and see whether they justified the dividend. If they didn't, that allows you, as I showed the court looking at section 837, to instead use interim accounts. So I accept that for that rather narrow purpose, they would have a very limited role. But then there's the second aspect of what the directors have got to do, which we dubbed, I hope helpfully, the should not question in the first set of proceedings, because that's the question of whether if they can lawfully pay a dividend, they should or should not do it in accordance with their fiduciary duties. Because profits may be available for distribution, but it might be a thoroughly bad idea to actually make a distribution. And there's the question of how much.
Rather topical subject, as a matter of fact.
Indeed. Indeed. In many spheres.
In many spheres, yes.
Yeah. So that, and now, in relation to the should not question, now the accounts that the could not question is objective. If the directors don't even look at the interim accounts, or the last annual accounts, whichever the relevant ones are, there's still an objective question that determines whether the dividend's lawful. Whereas the second question, the should not question, is subjective. It does depend on what the directors actually think. Now, when they're addressing that subjective question, they are, of course, going to look at the accounts, which are the relevant accounts under Part 23, obviously. But they may well look at other accounts as well. In fact, they certainly should, because they shouldn't. They have to take a wider view. And in particular, if they are looking at interim accounts, as the relevant accounts under Part 23, they must go back and also look at the last annual accounts, because any set of interim accounts are going to be based on the last annual accounts. They're a progression from them. They're not going to be audited in the same way that the last annual accounts were, but they will be based on the last annual accounts. And the last annual accounts, ex hypothesi, do not allow the payment of this dividend. So one's got to look back and see, okay, what's happened? Why do these interim accounts that I'm relying on in paying the dividend show something that allow me to do something that the last annual accounts didn't? And so you can't stick your blinkers on as a director and just look at the interim accounts in a situation like December 2008. You've got to look at the last annual accounts as well. So the reference by Maloney and Friend to the minute is with respect misguided. I also will recall. He showed recall the minute.
And I think he showed us the minute because Mr. Lloyd referred to it in his statement.
Yes, fair enough.
If I was following the
my lord's absolutely right.
argument.
Absolutely right. But what he got out of the minute, I'll rephrase my point, what he got out of the minute was misguided because he was trying to suggest that, well, all that showed is that they just entered into the mechanical exercise of seeing whether the 2007 accounts justified the dividend or not. I'm mindful of the time. See if I can just finish this point in the next minute, if that's
Yes, by all means.
useful. Thank you.
Yes.
Now, Maloney and Friend also says that, well, our case, that there's a link between the 2007 accounts and the December interims is flawed. No real chance of success, he says. Because he says, well, look at the findings of Mrs. Justice Rose, particularly refers to 185. They show that the provision was calculated afresh after the 28th of October 2008, when the 2007 accounts were approved. And so that the link is broken, he's effectively saying. Well, important link is 60% figure, and that isn't broken. And actually one can see that from the very paragraph that he referred to, which, as I say, is 185. Because
185 in Mrs. Justice.
in Mrs. Justice Rose's judgment, so that's volume 3, and it's on page 569. Made a lot about Mr. Bartolotta, who otherwise in these proceedings hasn't really figured at all, but he made his first appearance yesterday. And the suggestion was Mr. Bartolotta came along and redid the work on the provision. It's very important what sees at 185. Mr. Bart's second line, Mr. Bartolotta wrote to Mr. Martin and Mr. Gow on 10th of November setting out various queries which arose because he said, tried to put himself in the role of the auditor who was going to review the analysis, bearing in mind that auditors like consistency. In particular, he challenged the move of the figure away from the 60% that had been used in the previous accounts. So what Mr. Bartolotta is doing here is actually saying, no, keep consistency. He's saying stick to the 60% because that was what was in the previous accounts. I mean, you've not shown me any reason to change. So as regards the 60% figure, the crucial point, there is the very bit of evidence that, or it's not really evidence, but we'll come on to that PwC referred to in support of this, actually shows the opposite. It shows the 60% figure being kept because it is consistent. So one does, the main point we make in relation to this is that in relation to the actual content of the December interim accounts, an error as regards the share, the 60% in the 2007 accounts, does feed through. But we also say that when it comes to the directors looking at and relying on the 2007 accounts in paying the dividend, yes, they did.
Well, it's striking, isn't it, that you go on to the estimates, for example, the estimates of the 20th of November, which are in the next paragraph, 187. They're all either 60% or less than 60%. And so you could say, well, I mean, I think where you're getting to, saying, well, the 60% in the 2007 accounts was wrong for all the reasons you give. Let's say, for the sake of argument, it should have been 80%.
Yep.
If it had been 80%, then Mr. Bartolotta would have been proceeding on the basis that if we're going to be consistent, we should start at 80%.
Yes.
So it would have fed through,
Exactly.
one way or another,
Exactly.
to all the other figures.
Exactly, Mike. It's not that this idea that there's a clean slate is factually wrong. Certainly, the court can't conclude that there's no real prospect of it being factually wrong. And in fact, there is a feed through. Whatever, as my lord says, whatever it should have said, if it was something more than 60%, that would have fed through. It should have fed through. It's highly contentious as to what the effect of the developments over autumn 2008 were, both before and after the 2007 accounts. So we can't for a moment try to get into that, but you can see the link between the two. Sorry, we've gone 5 minutes over.
Your 1 minute proved slightly elastic, Mr. Thompson, but never mind. How are you doing for time generally?
I think okay. I think I need to finish in order to give my learned friend, I think it's, so I have 40 minutes, 45 minutes yesterday. So I'll make sure I do that.
Well, you need to finish by 3:30 is really the bottom line.
Yes, I think, yeah,
yes.
that's it, yes.
Well, as long as you take that as your deadline.
I will do that.
In that case, I mean, would it help? I mean, if we gave ourselves an hour for lunch, I'd say 2:05, but if you would prefer us to come back at 2, I'm sure that would be absolutely fine.
Well, I'm sure the 5 minutes will be okay. So let's
Okay, in that case, we will resume at 2:05. Thank you very much.